We are on the record for hearings on the matters listed in the North Dakota Industrial Commission hearing docket for December 18th. I am David Garner, hearing examiner for these hearings. We're at the hearing room for the Department of Mineral Resources, Oil and Gas Division, and it is 9 a.m. On the docket, the following matters will be continued or dismissed. Case number 32439 continued. Case number 32056 dismissed. Case number 32049 continued. Case number 32050 continued. Case number 32051 continued. Case number 32052 continued. Case number 32083 dismissed. Case number 32330 continued. Case number 32335 continued. Case number 32336 continued. Case number 32337 continued. Case number 32053 continued. Case number 32170 continued. Case number 32338 continued. Case number 31676 continued. Case number 32253 continued. Case number 32343 dismissed. Case number 32349 continued. Case number 32350 continued. Case number 32351 continued. Case number 32352 continued. Case number 32353 continued. Case number 32354 continued. Case number 32355 continued. Case number 32356 continued. Case number 32357 continued. Case number 32358 continued. Case number 32359 continued. Case number 32360 continued. Case number 32361 continued. Case number 32362 continued. Case number 32363 continued. Case number 32177 continued. Case number 32178 continued. Case number 32086 continued. Case number 32087 continued. Case number 31682 continued. Administrative docket starts on page 5 with case number 32448 and goes through case number 31682 on the supplement. These cases will be heard in the next room with Michael Zish. Audio recordings of the cases on the administrative docket will be placed on the Oil and Gas website by the end of the week. If you wish to appear on one of the matters in the administrative docket, please appear in the next room. If there is opposition to the matter, will be brought back into this hearing room to be heard, and your statements and evidence will be taken. We'll begin with moving to case number 32346. Application of Hunt Oil Company for an order of the Commission amending the field rules for the Ross Bonkin Pool and or Stanley Bonkin Pool, Montreal County, North Dakota as follows. 1. Create and establish an overlapping 1920 acre spacing unit comprised of sections 24, 25, and 36, Township 156 North, Range 90 West, authorizing the drilling of a total not to exceed 3 wells on said proposed overlapping 1920 acre spacing unit. And 2. Terminate an existing 1920 acre spacing unit comprised of sections 36, Township 156 North, Range 90 West, and sections 1 and 12, Township 155 North, Range 90 West, authorizing the drilling of a well on said existing 1920 acre spacing unit and such further relief. All interested parties, please come forward.
Thank you, Mr. Appeal Box 1854, Bismarck, North Dakota. Here in this case, 32436 on behalf of Hunt Oil Company.
Mr. Harkins,
Good morning.
do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
Yes,
Is that beautiful downtown Dallas behind you?
correct.
Okay. Ryan, by whom are you employed?
Hunt Oil Company,
In what capacity?
landman.
And in that capacity, have you testified before the commission previously
Yes,
and had your qualifications accepted as that of an expert?
yes,
Offer the further testimony of this witness that of an expert.
Motion granted.
Ryan, I assume you have a packet of exhibits in front of you for 32436.
correct.
Let's go to Exhibit 1. And what I'd like you to do is identify Exhibit 1 and then briefly discuss what's contained upon it.
Exhibit 1's a regional location map showing the Ross Field highlighted in red and also the Stanley Field highlighted in red.
Okay.
They're both in Montreal County.
Okay. And then Exhibit 2.
Exhibit 2 shows the existing 1,280 acre unit consisting of sections 24 and 25, 156 North, 90 West, and Hunt's working interest therein being 58%. Shows Hunt's working interest in section 36 being 75%, and then the proposed 1920 acre unit outlined in red dashed where Hunt's working interest is 64%.
No further questions of the land witness.
Any questions from the staff?
Ryan, you neglected
Yes.
you neglected to indicate that section 36 of 156.90 and 1 and 12 of 155.90 are currently in stand-up 1920.
Correct. Yeah. So we have had communication with Phoenix, the operator of that unit. They have no issues with Hunt's current plans of this proposed 1920 acre unit. Sections 1 and 12 and 36 currently have no wells in it, and sections 1 and 12, I believe, are a mixture of unleased interest or term leases.
So can you submit something from Phoenix, or at least their acknowledgement that they have no issue with terminating that spacing unit?
Yes, I can.
Okay, thank you.
We haven't. I mean, I've had email correspondence with them. I can provide that.
Okay, thank you.
Ms. Watkins,
Yes,
do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
I do.
Kathleen, by whom are you employed?
An oil company,
What capacity?
geologist.
And in that capacity, have you testified before the commission previously?
Yes,
Had your qualifications accepted as that of an expert?
yes.
Offer the further testimony of this witness that of an expert.
Motion granted.
Kathleen, let's go to the next exhibit in the packet. It's been previously marked as Exhibit 3. Can you identify Exhibit 3 and then briefly discuss what's contained upon it?
Yeah. Exhibit 3 is a structure map of the top of the Bakken Formation. Middle Bakken laterals are highlighted in blue, and Three Fork laterals are highlighted in red. The type log for Ross and Stanley Fields is circled in red, and the proposed 1920 acre unit is shaded in red.
Okay, and then let's go to the next exhibit, Exhibit 4. Tell us what that is. Excuse me.
Exhibit 4 is a type log for Ross and Stanley Fields. The Ross Bakken Pool is defined as 50 feet above the top of the Bakken Formation to 50 feet below the top of the Three Forks Formation. The Stanley Bakken Pool is defined as 50 feet above the top of the Bakken Formation to above the top of the Burr Bear Formation. Track 1 is gamma ray, Track 2 are porosity logs, and Track 3 are resistivity logs. The top of the Bakken Formation, top of the Three Forks Formation, and top of the Burr Bear Formation are shown in red, and the Middle Bakken Reservoir is highlighted in yellow.
Is Middle Bakken the only target at this point in time?
Yes.
No further questions.
Any questions from the staff? Mr. Goff,
Yes.
do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
Yes.
Zach, by whom are you employed?
Hunt Oil Company,
In what capacity?
reservoir engineer.
And in that capacity, have you testified before the commission previously?
I have, yes.
Had your qualifications accepted as that of an expert?
Yes.
Offer the further testimony of this witness that of an expert.
Motion granted.
Zach, let's go to the next exhibit in the packet, marked Exhibit 5. Can you identify and briefly describe what's contained on Exhibit 5?
Yes, that's the map depicting the proposed development for the proposed overlapping 1920 acre spacing unit. The unit in question is outlined in a red dashed line. The existing 1280 acre unit that we operate is depicted in light green with a darker green outline. All of our existing operated wells are in black, and the proposed wells to be drilled within the unit are in red with a kind of a yellow halo around them. Other existing wells that we do not operate are shown in gray.
Okay, then let's go to Exhibit 6. Excuse me.
So Exhibit 6 is a typical Middle Bakken wellbore schematic depicting the casing and completion design.
Okay, and what do you anticipate in terms of stages on your typical wellbore scheme?
For a 15,000 foot wellbore, we're around 90 stages, I believe, in this area.
So I'm sorry, can you say that again? I had a little trouble hearing you.
Scoot forward here. Sorry, for a 15,000 foot well in this area, I believe we're at about 90 stages.
At the bottom of this exhibit, it says approximately 150 stages, which is correct.
That says approximately 150 foot stages.
Oh, I'm sorry, I misread it. Thank you for clarifying that. Okay, let's go to Exhibit 7. As you did with the previous exhibits, identify and then briefly discuss.
Yes, so Exhibit 7 is typical Middle Bakken reservoir properties, reserves, and economics for the Ross or Stanley Bakken pool for a 15,000 foot lateral. Approximately 8,800 foot TVD, roughly 5,400 PSI expected bottom hole pressure, 42 API gravity oil, with a net pay of about 28 feet in the Middle Bakken, porosity of 8.5%, 38% initial water saturation, and a formation volume factor around 1.25. So that yields a original oil in place of about 17.6 million barrels. For these wells in particular, we estimate 357 MBO recoverable, and 543 million cubic feet. Yields approximately a 2% recovery factor per well. Average investment, so all the economics run that are shown are at a realized pricing of $65 per barrel of oil and $2.50 MCF flat pricing. Average investment for this well is about $8.7 million. PV0 is roughly $5 million, and PV10 is roughly $1.7 million, with a undiscounted rate of return of 20%. Return on investment is approximately 1.6.
And Exhibit 8, is that a gas capture affidavit that the Commission typically requires in these sorts of matters?
Yes, it is.
And in your opinion, Zach, will the requested relief prevent waste, protect drilling rights, and prevent the drilling of unnecessary wells?
Yes, it will.
Mr. Examiner, no further questions. Offer the exhibits.
Exhibits are admitted. Any questions from the staff?
Zach, looking at your Exhibit 5.
Yes, sir.
Yeah, the 3 wells that you're proposing to drill in here, you have depicted on this exhibit, are they planned to be exactly as depicted, or will there be some additional development? Will the well in 36 reach over to that west half of 36?
The west half of 36. Yes, I believe at this moment we are planning on developing that as a lease line, if I'm not mistaken. So wouldn't be included in this particular spacing application.
So between the well you have on this exhibit, roughly down the center of the spacing unit, and what you just said is a potential lease line on the western edge or the section line of 36, you have about half a section. Will there be any well bores or anything producing out of that west half of 36?
Aside from our planned lease line well, you're asking about the southern portion of the 3 mile unit in section 36 below the existing wellbore. Just for clarification, that's what you're asking about?
Yep.
Okay. No, as depicted is how we plan on drilling these wells. So we wouldn't drill an additional well kind of directly parallel with that existing one.
Okay. Any reason you wouldn't spread out the 3 wells that are in 36 when you get down in there?
This is how we have it planned, but no, to my knowledge, no technical limitation there.
Okay, thank you.
Zach, where's your proposed surface location for these wells?
On the north side, I forget if it's on the south side of section 13 to the north of this proposed unit, or if it's on the north side of section 24. But we plan to develop them in conjunction with the unit that we already have spaced to the north there, starting at section 13.
Yeah, it looks like you have some permits in the south part of 13.
Yeah, correct. Yeah. So our surface location is in the south portion of section 13.
With those other wells.
Correct.
Okay,
Yes.
thank you. Zach, when's the planned development date for this?
I believe it's second half of next year.
And so, also, is it the new pad?
Pardon?
Is it a new build pad or is it a pad reoccupation?
The pad's currently built for they're in section 13, where we're getting ready to build it.
Yeah, I'm unsure of the status for that pad.
I share the same concern about the west half of section 36 and the potential for that being underdeveloped and the potential to never be developed. And so, what Rich, I think, was alluding to was the ability for the well spacing when you cross over. If you're drilling from the north to south, is that correct?
That is correct. Yeah, from section 24 to down to section 36.
Yeah. So I think what Rich was talking about was when the well bore for the westernmost well that you have here, which runs right down the middle of the unit or the proposed unit. Is there a potential that western well bore, after it crosses into section 25, can angle to the west in section 36 and adequately recover additional reserves out of the west half of section 36? So our concern is that it would be underdeveloped acreage there, and the potential for it to never get developed.
Understood. And with the development of a lease line well here along the section line from section 24 to 36, with these additional 3 wells that are depicted here, we believe that'll be adequately drained. But again, if there's that concern, we can fan these wells out in section 36 as well.
Do you Zach, again, do you plan on doing anything different with completions down there, or same for each well?
It should be the same for each well.
Okay. Then I noticed that you ran the economics at $65 oil. Is that $65 WTI?
That's a realized price.
Okay, so it's
no additional differentials applied on that.
Okay, that has your North Dakota deduct in it.
That would be the assumption.
Yeah.
So it's $65 realized.
And given where pricing is right now, would Hunt plan to drill those in the current pricing environment?
That is our plan. We plan to continue drilling through next year.
Okay, thank you.
Can we follow up question? Oh, sure. Zach, to follow up on the questions that were asked by the director, the west half of section 36, as you have it depicted on Exhibit 5, does not have a well bore in it. Does that mean that the well that is going down the center of the section in section 36 will not recover the oil in the west half, or will it just take a little longer because it's just one straw that covers a larger area?
Correct. Yeah, that would be the assumption, is that that acreage will be drained by the wells proposed, and if you were to add any additional take points there, it would be a acceleration of those reserves.
So it's not a matter of creating waste by not having a well in the west half of 36. It's just going to take a little longer to recover that oil, and you can't justify drilling a 1 mile lateral to recover that oil on the same speed as the other portions of Section 36. Is that a fair statement?
Yes, I believe that's a fair statement.
No further questions.
If there's nothing further, is December 26th long enough to get that supplemented?
Is that next week, Thursday?
Well, it's the day after Christmas. I
Oh,
figured.
did you say the 26th?
26th.
Oh,
Yeah.
okay. I thought, yeah. I think that'll work. Zach, is that work? Ryan, Kathleen, does that work for you?
Yes, that should
Okay.
work.
You don't have vacation plans tomorrow and early next week that we can't get it done?
Our office is closed, but I expect I can get it today.
Okay. So yes, that'll work.
Okay.
Yes, correct.
The
Thanks,
record
Ryan.
will remain open in this case until December 26th. That concludes our hearing for case number 32436. Case number 32437. In the matter of the application of Devon Energy Williston LLC for an order amending the field rules for the Glass Bluff Bakken Pool, Foreman Butte Bakken Pool, and/or nameless Bakken Pool, McKenzie County, North Dakota, as follows: 1. Create and establish an overlapping 3,200 acre spacing unit comprised of the west half of section 27, all of sections 28, 29, 32, and 33, and the west half of section 34, township 151 north, range 102 west, or 2. Create and establish an overlapping 38, 40 acre spacing unit comprised of all of sections 27, 28, 29, 31, 32, and 33, township 151 north, range 102 west, or 3. Create and establish 2 overlapping 1,600 acre spacing units comprised of the west half of section 27 and all of sections 28, 29, and the west half of section 34 and all of sections 32 and 33, township 151 north, range 102 west, or 4. Create and establish 2 overlapping 1920 acre spacing units comprised of sections 27, 28, and 29, and sections 32, 33, and 34, township 151 north, range 102 west, authorizing the drilling of a total not to exceed 10 wells on said proposed overlapping spacing units, and for such other relief as may be appropriate. All interested parties, please come forward.
Thank you, Mr. Examiner. Lawrence Bender, P.O. Box 1854, Bismarck, North Dakota, appearing in this matter, case 32437, on behalf of Devon Energy Williston, LLC.
Ms. Adams,
Yes.
do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
Yes, I do.
Katie, we're having a little trouble hearing you. Can you get a little closer to the mic, or
Sure. One second.
it's improved a little bit since I mentioned it. So
Okay. Can you hear me better now?
yeah, much better. Thank you very much. I'll let you get settled, then I'll have a few introductory questions. So, Katie, by whom are you employed?
Devon Energy Williston LLC,
In what capacity?
senior staff landman.
And in that capacity, Katie, have you testified before the commission previously?
No, I have not.
What I'd like you to do, Katie, is briefly highlight for the examiner and the commission staff your educational background and work experience.
I graduated from the University of Oklahoma in 2015 with a BBA in energy management. And after graduating, I started my career as a landman at Devon Energy. So I've now been a landman here at Devon for over 10 years, working various assets. I also earned an MBA from Oklahoma City University in 2017.
And in preparation for today's hearing, have you made a thorough study and review of all the relevant land matters concerning the application of Devon that has been docketed as case number 32437?
Yes.
And have you prepared or had prepared under your control and supervision some exhibits that you intend to sponsor?
Yes.
You'll offer the further testimony of this witness that I'm an expert.
Motion granted.
Katie, let's turn to the packet of exhibits that I've distributed to the commission staff. I assume you have a packet in front of you.
Yes, I do.
Okay, what I'd like you to do, please, is turn first to what's been marked as Exhibit L1, Romanet 1, and I'd like you to identify that exhibit and then briefly discuss what's contained upon it.
Well, first, I'd like to state that as the commission knows, we have made application for several spacing options. We took this approach because we have plans to drill these wells soon, and we hope that one of these options will be approved. So first, on Exhibit L1, Romanet 1, I'll walk through the first of the 4 proposed spacing options. At the top, we have the regional locator map zooming into McKenzie County. And then at the bottom, we show the first proposed 320-acre overlapping spacing unit highlighted in yellow, and that's comprised of all of sections 28, 29, 32, and 33, as well as the west half of section 34 and 27, all in Township 151 North, Range 102 West.
All right, let's go to Exhibit L1, Romanet 2.
Okay, on Exhibit L1, Romanet 2, we show the same regional locator map at the top. The only difference with this exhibit is that we are now showing our second proposed spacing option, which is the proposed overlapping 3,840 acre spacing unit, which is comprised of all of sections 28, 29, 32, 33, 34, and 27. Again, all in Township 151 North, Range 102 West.
And Exhibit L1, Romanet 3.
On Exhibit L1, Romanet 3, same locator map again. This time we're showing our third spacing proposed. This is actually 2 proposed 1,600 acre spacing units. The spacing to the north contains the west half of section 27 and all of sections 28 and 29. And then the spacing to the south would contain the west half of section 34 and all of sections 32 and 33. And again, all in Township 151 North, Range 102 West.
And Exhibit L1, Romanet 4.
On Exhibit L1, Romanet 4, again, we have the regional locator map, and then highlighted in yellow, we show our fourth proposed spacing option, which is a proposed, 2 proposed overlapping 1,920 acre spacing units. The spacing to the north would contain all of section 27, 28, and 29, and the spacing to the south would contain all of section 32, 33, and 34, all in Township 151 North, Range 102 West.
Okay, let's go on to the next exhibit, Katie. Exhibit L2. And as you did with the previous exhibits, first identify the exhibit and then briefly discuss what's contained upon it.
Okay. On Exhibit L2, we're showing the existing spacing units that are operated by Devon. Starting from left to right, we have on the left in pink, we have the gelled spacing unit comprised of section 29 and 32. In the middle in green, we have the Safely Truss spacing unit comprised of sections 28 and 33. And then on the right, we have our, what we call our Albert spacing unit comprised of sections 27 and 34.
And let's go next to L3. As you did with the previous exhibit, identify and discuss what's contained on L3.
On Exhibit L3, we have an ownership breakdown of the furthest west existing 1,280 acre spacing unit covering all of section 29 and 32, also known as the gelled unit. In this unit, Devon Energy owns 71.11% working interest. Vitesse Energy owns 14.23% working interest. Headington Oil owns 5.4% working interest. And all of the other owners collectively own 9.25% working interest.
L4.
Exhibit L4 is an ownership breakdown of the existing 1,280 acre spacing unit comprised of sections 28 and 33. This is also called our Safely Trussed spacing unit. Devon Energy owns 92.08% working interest in this unit. PPJ Partners owns 3.3%, Vitesse Energy 2.9%, and all other owners own a collective 1.6% working interest.
Okay, and L5?
Exhibit L5 shows the furthest west spacing unit. This is the existing 1,280 acre spacing unit comprised of sections 27 and 34, also known as our Albert spacing unit. In this unit, Devon Energy owns 97.23% working interest. Herman Oil and Gas owns 2.5% working interest. And JAG Oil owns 0.1875% interest.
Okay, now let's go on to the various proposed overlapping spacing units. Starting first with your proposed 3,200 acre spacing unit. You have that labeled as Exhibit L6 Romanet 1. Can you discuss that exhibit, please, Katie?
Yes, in Exhibit L6 Romanet 1, this is the ownership breakdown of the proposed overlapping 3,200 acre spacing unit as depicted. In this proposed overlapping spacing unit, Devon Energy would own 84.73% working interest. Vitesse Energy would own 6.86% interest. Headington Oil 2.16%, and all other owners 6.24% working interest.
L6 Romanet 2.
In Exhibit L6, Romanet 2, this is the ownership breakdown of the proposed overlapping 3,840 acre spacing unit. In this proposed overlapping spacing unit, Devon Energy would own 86.81% working interest. Vitesse would own 5.72% working interest. Headington Oil would own 1.8%, and all other owners would own 5.66% working interest.
L6 Romanet 3.
Exhibit L6 Romanet 3 shows the ownership breakdown for the proposed overlapping 1,600 acre spacing units. I will note that the ownership in both of these units would be identical. The unit to the north covers the west half of section 27 and all of section 28 and 29. The unit to the south would cover the west half of section 34 and all of section 32 and 33. And in both units, Devon Energy would own 84.73%, Vitesse Energy 6.86%, Headington Oil 2.16%, and all other owners 6.24%. And this working interest does match that of the 3,200 acre proposed spacing.
Okay, let's go on to the next exhibit then, and if there's any typos on this exhibit, please correct those for the record.
Yes, this exhibit should be titled Exhibit L6 Romanet 4, not Romanet 3. And this exhibit is showing the ownership breakdown for the two proposed overlapping 1,920 acre spacing units. The spacing to the north is comprised of all of sections 27, 28, and 29. And the spacing to the south is comprised of all of sections 32, 33, and 34. Again, the ownership in these two proposed spacing units would be identical. And in them, Devon Energy would own 86.81%, Vitesse Energy 5.72%, Headington Oil 1.8%, and all other owners 5.66%.
Now, of the four proposed alternative spacing units that Devon has made application for, does Devon have a preference of which spacing unit they would like the commission to approve?
Our initial preference was the proposed 3,200 acre spacing unit. I think that makes sense based on our development plans. However, based on our plans, we are okay with the two 1,600 acre spacing units as well. It will not change our plans whatsoever.
So just so we're clear for the record, Devon's preference would be the spacing unit that's depicted as L6 Romanet 1, correct?
That is correct.
But Devon wouldn't have any objection if the commission were to determine that L6 Romanet 3 is more appropriate. Is that correct?
Yes, that is correct.
Now, you mentioned in your introduction that Devon made the application for alternative spacing units because of timing. In other words, Devon is anxious to go out and commence operations to drill the well. Can you tell us a little bit about that? What are Devon's plans with respect to commencing operations? And when I say commencing operations, not necessarily spudding, but getting a permit and authorizing or having the ability to start the dirt work.
Yes, right now our spud date for a spudder rig is scheduled in February of 2026. And because we do not have a permit yet, we have not been able to start our construction on the pads. So as soon as an order is issued, we will begin that construction and hopefully target that February spud date with a spudder rig. We will follow with the larger rig either in late March or early April, shortly thereafter.
And has that commencement of drilling, or excuse me, the commencement of operations date and the spud date been moved back a bit from what Devon initially thought it would be doing in terms of commencing operations out here?
As of now, in my time working this asset, we have had plans to spud in Q2 of 2026. We're trying to hold on to those plans, but we may have to push it back further depending on the timeline of receiving permits.
Okay, I want to make sure that I understood your answer. Was there some initial plans at Devon to commence operations? I'm not saying spudding, but commencing operations, like doing the dirt work, getting the permit, and all that in place a little bit earlier, but that was pushed back a bit?
Yes, I apologize. I misunderstood the question. We did have plans to start the dirt work prior to the winter. We had plans to start in November of 2025. So this will be a winter build, and that the timeline of that can be a little bit more unpredictable. So the sooner we can get started, the better.
Do you have an idea of what would work best for Devon in terms of getting an order from the commission and then allowing a permit to be issued? Is it a month from now? Is it 2 weeks from now? What would be ideal for Devon? That doesn't mean you're going to get it, but just tell us what you believe is ideal.
Ideally, as soon as possible. I understand that there's a lot that goes into issuing an order, but ideally as soon as possible.
Okay. Well, it's Christmas. You get to ask what date.
I mean, today would be incredible that we could.
Well, I don't think that's going to happen, but realistically, is a couple of weeks, is that going to get it done for you?
Early January would solidify our spud date. I think if it's any later in January, we will have to adjust our schedule so that we can plan accordingly, because there's just so many moving parts with our rig schedule.
Okay, thank you for that, Katie. I don't have any further
Yes.
questions of this witness.
Any questions from the staff?
Katie, when we're looking at the various spacing units, I just want to ask a couple quick questions. The existing wells on 27 and 34, those are all on a stand-up 1280, correct?
That's correct. Yes.
And so the three wells in the east half of 27 and 34 are paid to the west half of 27 and 34, correct?
Sorry, can you repeat that?
The three wells that have been drilled on the east half of 27 and 34, they've paid out to the west half of 27 and 34 as well.
That is correct. That ownership is based on the spacing, the 1280 acre spacing unit.
Yep. So when you come in and drill, and your preferred option, L6 Romanet 1, the 3200 acre. When you drill that spacing unit with the underlying spacing units, can you give me a rundown of how proceeds from that acreage will be distributed to the acres within the spacing unit and to the underlying spacing units?
Yeah, so the total acreage contributed from each existing spacing unit would be taken over the total acres in the proposed spacing unit for the allocation factor. So for the example on Exhibit L6, Romanet 1, the gelled spacing unit and the safely trussed spacing unit, those would each be credited with 40% of the total, or 2/5, and the Albert spacing unit would be credited with 20% or 1/5.
And that 1/5 proceed that goes to the Albert unit, how is that distributed?
That would be distributed amongst all of the owners in the 1,280 acre existing stand-up spacing unit.
And that's due to the underlying pooling?
Correct.
And I guess functionally, how does that change if we go with, we'll say, L6 Romanet 2?
So with L6 Romanet 2, because the spacing is spaced at 3 miles and fully contains all of the existing spacing units, in this example, each existing spacing unit would be credited with 1/3 of the proceeds. So that is where you see the adjusted interest and the working interest breakdown.
Okay, and
But
then
it's
I think that's good for that. But then one more, just to confirm, when we go from your L6 Romanet 1 to Romanet 3, the ownership there that you're depicting, you're saying is the same for each of those 1,600 acre spacing units. It doesn't deviate from the north one to the south one.
That is correct when you're using the pooled existing spacing units to calculate the interest. It doesn't necessarily matter whether it's the 3,200 acre or 1,600 acre. I would be working from the existing spacing units to come up with that interest. So you're really just cutting it right down the middle of those existing spacings.
And I'm assuming there is a difference in mineral ownership from the north half to the south half.
That is correct.
Okay, thank you.
Thank you.
Mr. Creeman,
Yes,
do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
yes, I do.
Drew, by whom are you employed?
Devon Energy,
In what capacity?
senior geologist.
And in that capacity, have you testified before the commission previously?
I have not.
What I'd like you to do, as Katie did, is briefly highlight your educational background and work experience.
Of course. I hold a master's degree in geology. And after that, I worked 10 years at another operator here in Oklahoma. After that position, I served the public for 2 years at the Oklahoma Corporation Commission as a regulatory manager in the UIC and induced seismicity departments. After that, I came to Devon, where I worked for 2 years in business development and looking at A&D, and then I moved into my current position as senior geologist.
And in preparation for today's hearing, Drew, have you made a thorough study and review of all the relevant geologic matters concerning this request in case number 32437?
Yes,
And have you prepared or had prepared under your control and supervision exhibits you intend to sponsor?
yes.
I'd offer the further testimony of this witness side of an expert.
Motion granted.
Okay, Drew, let's continue in the packet of exhibits that I've distributed to the commission staff. Katie went through the land exhibits. I'd like you to start with exhibit G1, identify Exhibit G1 and briefly discuss what's contained upon it.
Yes, exhibit G1 is showing the structure map and the offset well log location here in Township 151 North, Range 102 West. The red star represents the type well location of the Mirachek well that will be on the next exhibit. The structure contours on this map are at 10 feet. And what you can see from the structure is it's dipping gently to the east. So from west to east, structure is dipping in that direction.
Okay, let's go to Exhibit G2.
On Exhibit G2, this is the offset well log or our type log here. The tracks for this Mirachek well, first track is the gamma ray log, which is the black curve. The second track is the resistivity, which is the red. And then the third track shows the porosity logs, both the neutron and density. So you get an idea of the reservoir properties. We've also highlighted the formations throughout here from Lodgepole all the way to Three Forks Third Bench. And then pointing out our middle Bakken with the red arrow, which will be the reservoir that we will develop.
No further questions.
Any questions from the staff? Mr. Shute,
Yes,
do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
I do.
Mark, by whom are you employed?
Devon Energy.
In what capacity?
I'm an advising reservoir engineer.
I'm sorry, can you repeat that?
An advising reservoir engineer?
And in that capacity, you've testified before the commission previously?
Yes, I have.
Offer the further testimony of this witness that of an expert.
Motion granted.
Mark, let's turn to the next exhibit in the packet. It's been marked as Exhibit E1 Romanet 1. And what I would like you to do is identify that exhibit and then briefly discuss what's contained upon it and how it's pertinent to the application that's before the commission today.
Okay, Exhibit E1 Romanet 1. This is a map showing our preferred spacing. So spacing unit is 3,200 acres. It's outlined in red box. On the map, there are several existing Bakken wells. Those are in black, solid lines. There's one Three Forks well that's dashed black line. So within the 3,200 spacing unit, there are three existing Bakken wells. Outside of the proposed unit or preferred unit, there are three wells, two Bakkens, one Three Forks. The proposed wells are red going east-west. They plan to be drilled from two surface locations, and those are on the east side of this map.
All right, then let's go to Exhibit E1 Romanet 2, and perhaps looks very similar to Exhibit E1 Romanet 1. Perhaps the best approach might be to just point out differences between this exhibit and the previous exhibit.
Yep, it's the same exhibit, same lateral length, same surface hole locations for the new wells. The only thing that changed is the spacing unit outline. So this is the 3840 acre unit.
Okay, and then Exhibit E1 Romanet 3, and as you did with the previous exhibit, save some time, please just point out differences.
Yep, Romanet 3 is just like Romanet 1, except the unit is cut in half. So we have two 1,600 acre spacing units. The rest is the same.
Okay, and if it's my understanding from Katie's testimony that in the event the commission does not grant Devon's preferred spacing, which you have outlined as E1 Romanet 1, then you prefer E1 Romanet 3, is that correct?
Yes, that's right.
Let's go to Exhibit E1 Romanet 4.
Okay, the final one in this series is the same as Romanet 2, but the units are cut in half. So we have two 1,920 acre units. Everything else is the same.
Okay. Let's go to Exhibit E2.
Okay, Exhibit E2 is our wellbore schematic. It's typical of our designs in this area. Surface casing, 9 5/8, set at 2,200 feet. Intermediate casing will be 7-inch, set at 10,500 feet roughly, with a 4.5-inch cemented liner going to about 23,000 feet. The completion will be our typical completion also, about 63 plugs, about 1,000 pounds per foot, about 24 barrels per foot. And again, this is about 12,500 foot lateral. And with all these options, the wellbores don't change. They're all about 12,500 feet.
Okay, and Exhibit L3.
Exhibit L3 is our reservoir characteristics. These will all be Bakken wells, TVDs, 10,780 feet. Roughly the net pay about 26 feet, porosity a little over 6%, water saturation a little over 54%.
And E4.
E4 is our well economics. So the reserve basis, initial rate, we're planning on about 1,500 barrels of oil a day. Our GOR is a little under 1,500 standard cubic feet per barrel. Our oil EUR is a little over 400,000 barrels. Our gas EUR is a little over 600 million cubic feet. And the EUR equivalent is a little over 500,000 barrels equivalent. Then for the economics, we did run these a little while back. So the oil price we used was $70, gas price $3. The total cost to drill and complete equip is about $8.2 million. Operating costs a little over $12,000 a month, with the rate of return a little under 100%.
And then Exhibit GM1, is that a gas capture affidavit that the commission typically requires in these sorts of matters?
Yes, it is. We're lined up to have ONEOK handle everything as far as the gas capture.
Mark, in your opinion, will the requested relief prevent waste, protect relative rights, and prevent the drilling of unnecessary wells?
Yes, it will.
Mr. Examiner, no further questions. Offer the exhibits.
Exhibits are admitted. Any questions from the staff?
Mark, just to confirm, you did mention it, but your intent would be in any scenario, any spacing scenario at least, would be to drill the wells exactly the same. Is that so you wouldn't adjust your landing point for your 7-inch casing? I'll use a specific example. So like E1, your landing point would be the same as in so E1 Romanet 1 and E1 Romanet 2. You'd have the exact same wellbores.
Yes, that's the plan.
Okay, thank you.
Hold on a second. We take a brief recess. I'd like to go to Mark.
Sure. Why don't we take our 10-minute morning break?
Is
that okay?
Do you want the witnesses to stay on?
Yes.
Okay.
They want to say. Okay, this time we'll take a 10-minute break.
Did you all hear that? The case is not over, but we're going to take a brief recess.
Yep.
Okay,
Okay.
sounds good.
Great.
Okay, we are back on the record with case number 32437, and we will continue with questions from the staff.
So Mark, on exhibit E1, Romanet 1, and E, well, that's fine, or E1, Romanet 3, excuse me, 4.
Which one?
The one and 4.
4. Okay.
I believe it was your testimony that the wells would be drilled identical regardless of which spacing unit was established.
Yes, that's right.
So in order to include the east half of 27 or the east half of 34, if that was the spacing that was ultimately established, would you land your production casing somewhere near the boundary, the north-south quarter line, or even a little bit east of that to try to pick up some of that, the reserves between those, the well in the west half and the well, the furthest west well in the east half?
No, that's a good question. I've looked at that in pretty good depth. So we would land, so you're kind of talking about perforating in between the Albert 1H and then the Albert, I think it's 3H, in that window. And we have, I think the northernmost well would be in that window because the distance between the wells is larger. So I think there's enough reserves in there that we wouldn't have major depletion problems, and we'd be able to get out incremental oil from that northernmost well. So it's perforated in between the two. The other wells, I think there's just so much depletion that's occurred between those two that we won't get very much, or we'll probably get very little incremental oil perforating in between those two wells. And in addition, if we do that, we'll have, I think, significant depletion issues when we try to drill out and produce these wells. So we're not planning on producing in between the Albert 1 and the Albert 3, which is, kind of shown on the map there. That's kind of why we drew the wells in the way we did.
So these wells, if I'm correct, are 2012, 13 vintage, is that right?
That's right. They're in that range.
And do you believe the fracture stimulations were adequate at that time to drain all the reserves between those wells?
They're pretty good wells. The Albert 1H is almost a 500,000 barrel well. It's a good well. And then the Albert 3H is probably about 400,000 barrel. Like they're pretty good wells for that vintage. I was a little bit surprised, but when I did the volumetrics in between those wells, I think it's pretty well drained. We have pretty good experience drilling infills like that. So with wells that are spaced that tightly, with that high of an EUR, even though they are that old, we haven't had great luck.
Well, I think it's hard for the commission to justify including the east half of 27 or the east half of 34 if there's no drainage that's going to occur from those lands. And from a correlative rights standpoint, that's probably the appropriate spacing unit. But then if you go to the 1600 or the 3200, then there is a dilution effect of how the royalties are going to be distributed, according to what I believe Kate testified to.
That is correct. With the 3,200 acre proposed spacing unit or the two 1,600 acre proposed spacing units, the base Albert spacing unit, that existing spacing unit, those interest owners would not be credited with as high of a proportionate share as the owners in the GELD and the Safety Trust. It would be based on the acreage contributed from their existing spacing.
And like I said, that concern gets greatly reduced or eliminated if there is some capture of those reserves between those two westernmost wells. But it sounds like that's not something Devon would consider.
Do you understand the question? I'm not sure that I do. And who are you addressing it to, Mark?
Well, I was questioning Mark, so.
Okay, well, but
Uh,
Katie was
I'm sorry.
answering the question, so.
Sure. Yeah. So based on what was said that, or what I think I heard is Devon acknowledges there could be a dilution effect, but that the drilling of these wells to include a perforation or a take point near the quarter line is not something that they feel that they would consider.
We're planning on being what, 100, just the typical spacing rules, 150 feet off the the line there.
But if you have the entire three sections, then that of course that setback doesn't exist anymore.
I think,
Yeah,
Mr. Board, just excuse me for a moment. I think it's important, Mr. Board, to understand we came to the commission with alternatives so that we can get an order. If we had not come with this alternative and you were heading down this path, it could be denied. So we're here with about every possible alternative that we can present in the hopes that the commission will find that one of these is something that accomplishes the protection of crowd rights, prevents waste, and prevents the drilling of unnecessary wells. As you saw in the testimony that Katie presented, the working interest pretty much stays the same for Devon regardless. Preference, Katie pointed out the preference. But these other things, if you're having trouble with them, we're not going to have a problem with it. We just came to you, as I indicated, with a number of alternatives so that we could end up with an order because we want to drill this in February. So if E1 Romanet 4 troubles you and you want to deny that request, that's not going to cause us a problem. We prefer the two preferences that Katie suggested.
Yeah, we appreciate the options, but I think at this point, without further, well, we'll have to think about it further. But I think there's still issues with each one of them, and we're trying to get to a point where we can something that we're comfortable approving.
I don't know that there's any more alternatives, though. If you deny these, I don't know that we can come back with an alternative. And so then what do we do? Just not develop anymore in this area?
No, that certainly is not what we want to see happen. We want to see these wells get drilled, but like I said, we want to, for instance, if Devon had come in today and said, we're setting casing between these two westernmost wells, and wherever it is in there between those two, I'd say the 1920, we'd have no issue with it.
Can I ask a question for Mark?
Yeah.
Lawrence, I want to point out that it's we have the same goal of developing this acreage effectively and efficiently. Mark, is there an option to maybe shut in or repressurize the Albert 1H and the Albert 3H and allow the concern of the depletion between the two when you're drilling out to be solved, and therefore your first take point is in the eastern half of section 27 and section 34.
We we've discussed, we haven't discussed shutting in, but we've certainly discussed drilling, putting perforations in that area. And we've had a number of problems with depletion, specifically at the heel drilling out. I mean, there's instances where we just don't complete during that part of the lateral. So operation, reserves wise, we think it's depleted. There isn't much oil there. And then on operationally, we think it's just will cause us a lot of operational issues. So our plan is to perforate. I think, we need to talk about this in a little more depth, but probably about 200 feet west of that Albert 1H well. We're not planning on perforating through that well. We want to be on the other side of it. And that's not very clearly depicted on our maps. So the only well that we want to perforate on the east side is that most northern well where the Albert 1H kind of swings over west. So I did kind of want to mention that, but we really don't want to perforate, have anything to do with in between the 1H and the 3H, just because of the depletion issues. And we've dealt with that a lot the past few years.
Okay. This question will be for Katie. Katie, are you able to provide the commission a pay deck for each one of these options that shows that the correlative rights of the mineral interest owners in 27 and 34 is accounted for appropriately? And I guess when I look at, I can go right down the list of the let me find your exhibits here. You outlined the ownership percentages on how you would allocate accordingly. And so on L6, Romanet 1, you had 40%, 40%, 20% is what you had indicated. And that option, again, has an issue with the 27 and 34. And I understand the balance between development and we actually have to find a solution for all of those. And so the challenge that we're having is that the correlative rights in 27 and 34, which is why Mark has asked the question of first take point being in the east half of 27 and 34. And so if that's absolutely 100%, there's no way that you guys can at least perforate in that portion of the wellbore, land your casing there and perforate, then I believe that we're going to need a pay deck for each one of these options that shows the correlative rights of 27 and 34 are protected accordingly. Is that something that you guys can provide? We're struggling with this, so we're trying to come up with ideas on how to move this forward. We want this to be developed just like you. We want it to be developed on the timeline that you want it to be developed on. But I think I've adequately outlined the challenge that we're struggling with.
Sure, I'm happy to provide supplemental information regarding the ownership. I will note that in that Albert existing spacing, Devon does own almost 100%. We own 97.23%. In terms of where the mineral split is versus the pooled 1,280 acre existing spacing unit, there will be differences because these leases are not, full 640 acre leases, but I can provide any detail that might help. I'm not sure that there's a more equitable way to do it, especially given the existing revenue that's been shared amongst the west half owners from the existing Albert wells. But I'm certainly open to discussing that. I want to make sure we handle it the most fair way. With my review, this felt like the most fair approach for properly allocating the owners. But again, I'm happy to provide any supplemental information that would be helpful.
Okay. And I would specifically, whatever you provide, I'd specifically be looking for the accounting methods that allow proper protection of correlative rights of the mineral interest owners specifically, and how it relates to 27 and 34. And so that's the concern that we have, is that those wells have been producing for that amount of time.
Well, Mr. Director, if I may, as you know, there's basically two approaches operators have been utilizing to allocate proceeds of production and expenses in overlapping spacing units. And one is to just allocate expenses and proceeds of production from the lands that fall within the overlapping spacing unit. The other approach is to take the position, if that overlapping spacing unit overlaps a existing pooled unit, that should be shared. In this pay deck that you have requested to be put together, are you just looking for what I'll call the standard approach, where you allocate not only to the lands that are in the overlap, but also the lands that are pooled therewith? Or can you help us on that? I want to get you what you want, what you need, and without delay. So if you could provide us with a little guidance on that, I think that might be helpful. And I'm not trying to be disrespectful. I just want to get you what you want.
No, that's good. I think it's the latter option, because within the spacing unit is where the challenge lies.
So you want you want pay deck information on the lands that are pooled with the overlapping spacing unit.
I believe so, yes.
Okay.
Mark, do you agree with that?
Yeah.
And or an engineering option that Mark outlined, and we talked with Devin Mark about, that allows production from the east half.
And Mark,
Okay, so I didn't quite understand that. So production from the east half?
East half of section 27 and 34, which would mean that you would have to land the wellbore somewhere between the two western wells in section 27 and 34, and perforate, and therefore produce from the east half.
I don't quite understand that. You want us to produce from the east half?
So the question that we've been struggling with or wrestling with here is that section 27 and 34 have three wells that have been producing for some time, and now there's the idea that they don't appropriately protect the correlative rights of mineral interest owners, specifically in those two sections when you add their lands in the underlying spacing unit into the larger spacing unit. So one of the two options that we've outlined may be adequate to move forward.
Yeah, I think the east half is fully developed. I mean, there's no plans. I think that the recovery factor is very high. There's no plans to add wells, refract, do anything. I think that's set as far as correlative rights. I mean, that's fully developed. The question of between the Albert 1 and the Albert 3, that's in the same boat. I think it's fully developed, except for maybe the very northern well where we plan to perforate. So I think we're good there. were really solid. Well, I tell you the truth, that northernmost well, we plan to perforate, in the 320 acre, recommended unit. Yeah, the east half, I think that's fully drained, fully developed, relative rights taken care of.
They're not. But
Well, I'll just two things. One is the owners in sections 27 and 34 have shared in the production from all four of those wells. And we understand that spacing patterns are changing at this time, but there was an expectation that they would recover oil from the west half of 27 and 34 at some point in the future on 1,208 acre spacing unit development, and that is not going to occur now.
Gotcha. Okay.
And then
Okay.
the other thing, I think, another thing I might want to take a look at is, can you supply the estimated ultimate recoveries for all 6 of these wells that are within these lands?
Again, I have them written on a piece of paper here. They range between about 222,000 barrels and about 460,000 barrels.
Mark, we'll submit that as a supplemental.
Yeah,
exhibit
just
in
submit
writing.
what the yields are for those 6 wells. And
How about,
No, I
how
understand.
about cumes and
that's fine.
estimated ultimate recovery?
And quite honestly, we'll probably run our own, but I just want to make sure that we're
Understood.
they're not.
then the latter option, Lawrence, on how production would be allocated with the underlying spacing unit accounted for as well.
Okay.
Yeah.
Anything further?
I don't want to belabor this, but can I ask a follow-up question or two? Mark, direct your attention to Exhibit E1, Romanet 4. You've got 3 wells in the east half of 27 and 34, correct?
Yes.
And you're going to be submitting to the commission the cumes on those wells and the estimated ultimate recovery on those wells. Is that correct?
Yes.
And as you have your wells depicted on Exhibit E1 Romanet 4, given the fact that the east half of 27 and 34 are fully developed, would it protect correlative rights to allocate the same amount of revenue to the east half of 27 and 34 as it would to the other tracts in the north half spacing unit, north 1920 acre spacing unit, and the south 1920 acre spacing unit, given all that production? If you don't know, just don't answer.
Yeah, I'm not sure.
Okay, no further questions.
Okay, so we need some supplements, obviously, to issue a quick order. We'll probably need them by December 26th as well. Is that possible?
Yes.
Okay. The record will remain open in this case until December 26th. That concludes the hearing for case number 32437. I'll now jump ahead to the supplement. Case number 31478. Application of Devon Energy Williston LLC for an order for the Hart Butte Bakken Pool and or Twin Buttes Bakken Pool, Dunn County, North Dakota, to create and establish the following. 1. 1280 acre spacing unit comprised of sections 4 and 9, Township 147 North, Range 92 West, authorizing the drilling of a total not to exceed 7 wells on said proposed 1280 acre spacing unit. And 2. An overlapping 2560 acre spacing unit comprised of sections 4, 5, 8, and 9, Township 147 North, Range 92 West, authorizing the drilling of a horizontal well on or near the section line between existing spacing units on said proposed overlapping 2560 acre spacing unit, and such further relief as appropriate. All interested parties, please come forward.
Lawrence Bender, P.O. Box 1854, Bismarck, appearing in this matter, case number 31478, on behalf of Devon Energy Williston LLC.
Mr. Benson,
Yes, Mr. Examiner.
Do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
Yes, I do.
James, by whom are you employed?
I'm employed by Devon Energy Williston LLC, a subsidiary of Devon Energy Corporation.
And in that capacity, have you testified before the commission previously?
I have.
Had your qualifications accepted as that of an expert?
Yes, I have.
Offer the further testimony of this witness that of an expert.
Motion granted.
James, let's go to the packet exhibit for this case. Let's go to L1. Tell us what L1 is.
Yes, L1 is a regional locator map of Northwest North Dakota with the area located in a yellow box.
L2.
L2 is an area locator map in which the application lands are shown there as a 1280 acre basis on section 4 and 9 in a yellow outline. Also depicted on the map is Twin Buttes unit outline in green.
And
They're 147 North, Range 92 West, Dunn County.
okay, excuse me for interrupting. L3.
L3 is a land ownership plat of Township 147 North, Range 92 West, Sections 4 and 9 of Dunn County, whereby we've got a 1,280 acre space unit comprised of allotted and tribal federal lands, in which Devon contains a leasehold working interest of 27.9%. Ford has approximately 51.5%, and the remaining balance of 20.6% of other working interest parties.
And L4.
L4 is an area locator map of Township 147 North, Range 92 West, all of sections 4, 5, 8, and 9, whereby we've got a 2560 acre spacing unit, Dunn County, North Dakota, whereby we have also a Twin Buttes unit outlined as well. I will want to supplement the record a little bit too, kind of go back on the previous slides, but I will speak to this. There are existing stand-up 640 acre units, whereby on the east half of sections 4 and 9, the west half of sections 4 and 9, the east half of sections 5 and 8, the west half of sections 5 and 8. They're not depicted on this plat, but they do exist in the Heartview Bakken Pool. And also there's a 1,280 acre unit comprised of the east half of section 5, the east half of section 8, the west half of section 4, and the west half of section 9. I just wanted to call that out. They're not depicted on the map, but they do exist. This application is essentially to reconform the units to comprise of the existing 1,256 acre that's shown on this plat and the corresponding 1,280 acre unit. So just want to be clear on that point, and certainly I know I said a lot there, but if you have any questions, please let me know.
And with respect to any spacing unit that might exist inside the area you're proposing to be spaced on Exhibit L4, if it's not been drilled, you're asking that the spacing unit be dissolved. Is that correct?
Yes, sir, that's correct.
Okay. L5?
L5 is a land ownership plat of Township 147 North, Range 92 West, all of sections 4, 5, 8, and 9 of Dunn County, North Dakota, whereby Devon owns approximate working interest 13.95%. Cord has approximate 41.56%, and the remaining balance with other working interest owners.
No further questions.
Any questions from the staff?
James, is
Yes, sir.
so the east half of 5 and 8 are a stand-up 640. Is that correct?
Yes, sir, that's correct.
And are 4 and 9 a stand-up 1280 at this time?
No, sir, they are two stand-up 640s comprised of the west half of 4 and 9 and the east half of 4 and 9, separate 640 stand-ups, whereby I think the current field rules allow for 2 wells to be drilled on each stand-up 640.
Okay. And then the southeast of 9 is in the Twin Buttes Federal Exploratory Unit. Is that correct?
That is correct. Yes, sir.
And how does that have any effect on this spacing unit?
It does have a working interest component effect on it. The Twin Buttes unit is operated by Devon Energy, and that is part of our comprising working interest total on the map. And that Twin Buttes exploratory unit is currently in the Twin Buttes Bakken field, or I should say pool 2.
Yeah, but the fact that that is a part of the federal exploratory unit, it just means that the proceeds from that southeast quarter then get distributed to the rest of the federal exploratory unit.
Yes, sir.
But from the space unit consisting of 4 and 9, or 4, 5, 8, 9, it really doesn't have any effect on those space units.
No, yeah, from that perspective, it does not have the effect. It just has the allocation, cost and revenue dispersed to that quarter, southeast quarter of section 9.
Okay, thank you.
May I follow up with a question
Sure.
too? James, let's go back to your exhibit L5. I'd like to go through this one more time so it's very clear. The east half of 4 and the east half of 9 constitute a 640 acre spacing unit, is that correct?
Yes, sir, that's correct.
And no wells have been drilled on that spacing unit, correct?
Yes, sir, that is correct.
And
No wells.
And the west, okay, I hope I said no wells. And the west half of 5 and the west half of 8 constitute a 640 acre spacing unit, is that correct?
Yes, sir, that is correct.
And there are some wells drilled on that spacing unit, correct?
Yes, sir, that is correct.
Okay, and the west half of 4, west half of 9, east half of 5, and the east half of 8 constitute a 1,280 acre spacing unit, correct?
Yes, sir, that's correct.
And what you're requesting is that dissolution of the 640 comprised of east half of 4, east half of 9, and the 1280 that you just described, west half of 4, west half of 9, east half of 5, and east half of 8, correct?
Yes, sir, that's correct.
So the only thing that will be left is if application is granted would be the 640 that you described as the west half of 5 and the west half of 8.
Yes, sir, that's correct.
Okay. As a supplement, could you prepare an exhibit that would lay these 3 spacing units out on a map?
Yes, sir.
Okay. No further questions.
Okay, my information is indicating 4 and 9 are a stand-up 1280, so give me a minute. I'm going to try to confirm that.
I couldn't hear you, Mark. You got to talk a little louder.
It appears 4 and 9 may already be a 1280, but I just want to confirm that. I'm looking through the order real quick to see if I can confirm that or not.
I don't know if you know the answer to that question, James. I do not know the answer. But
When I reviewed these lands, I did not see a standard 1280 on sections all of 4 and all of 9. However, if that is in existence, certainly would alter my testimony. But my understanding is that it doesn't currently exist. But
and if that's
certainly,
the case, Mr. Bohr, then we just wouldn't need the request for the 1280 of 4 and 9 that we have in our application.
I'm going to try. I have, according to order 34129, zone 30, it shows 4 and 9 as a stand-up 1280 that allows up to 8 horizontal wells.
Okay.
That's what I am seeing right now.
Okay.
And our request is not to exceed 7.
Yeah.
But I think if it was 8, I don't see that as a problem.
Yeah. Okay.
Mr. Anderson,
Yes.
you solemnly swear affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief.
Yes, I do.
Sloan, by whom are you employed?
Devon Energy Williston LLC,
What capacity?
senior staff geologist.
And in that capacity, have you testified before the commission previously?
I have not.
What I'd like you to do is briefly highlight for the examiner your educational background and work experience.
Certainly. So in 2011, I received a Bachelor of Science in Geology from Oklahoma State University. After that, I received a Master of Science in Geology from the University of Tulsa. And shortly after that, I started my employment with Devon Energy, where I've been here a little over 12 years, working a variety of basins, handling all types of exploration and development type matters.
And in preparation for today's hearing, have you made a thorough study and review of all the relevant geologic matters?
Yes, I have.
And have you prepared or had prepared under your control and supervision exhibits you intend to sponsor?
Yes.
Offer the further testimony of this witness out of an expert.
Motion granted.
Sloan, let's go to the next exhibit, G1. Can you tell me what G1 is?
Okay, so G1 is an Upper Bakken structure map. The contours are on a 10-foot contour interval of the subject area. You can see there's a gentle dip off to the west, no major structural features through this area. The red star shows our type log, which is the Young Bear number 1. It's shown on the following exhibit. And we're showing all producing wells on this map here.
G2?
So G2 is the type log indicated on the prior exhibit. You can see on the left, track 1 is gamma ray log, the resistivity log, the track 2, and then the porosity logs in track 3. I've also identified the formation tops for the base of the lodge pole, the Bakken, as well as the Three Forks and Bird Bear formation that are consistent relative to this area, as well as noting the common target intervals of this area, which are the Middle Bakken and the first bench of the Three Forks.
No further questions.
Any questions from the staff?
Just confirming you do intend to target both the Middle Bakken and Three Forks with the proposed wellbore?
Yes, that's most likely.
And when you say Three Forks, it is just the first bench of the Three Forks, correct?
Yes.
Okay, thank you.
Mr. Caldwell,
Yes.
you solemnly swear or affirm under the penalty of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief.
Yes, I do.
Scott, by whom are you employed?
Devon Energy Williston LLC.
In what capacity?
I'm a advising reservoir engineer.
And in that capacity, have you testified before the commission previously?
Yes.
Have you had your qualifications accepted as that of an expert?
Yes.
Offer the further testimony of this witness out of an expert.
Motion granted.
Scott, let's turn to the packet of exhibits for this case. Excuse me. Yeah, for this case, E1. Tell us what E1 is.
Yes. So looking at E1, we're showing the proposed development layout for sections 4 and 9 and 147 North, 92 West. What we have depicted on the map are all of the existing producing wells in gray, which will be the Three Forks and the Bakken. And we are showing in dashed red the proposed Bakken wells and dashed blue the proposed Three Forks wells. This will be a 2-mile development with surface location in section 15, drilling, stepping out over to section 9, penetrating in section 9 and TDing in the north of section 4, where we'll have a total of the 8 wells, including the section line well, and that will be 4 Three Forks and 4 Middle Bakken planned wells.
And E2.
E2 is a typical wellbore schematic for a Three Forks well, where we will run 9 5/8 inch surface to approximately 2,000 feet measured depth. Then we will run 7-inch intermediate casing to an estimated 11,000 foot measured depth. And then a 4.5-inch cemented liner to TD at approximately 20,800 feet measured depth. And then from there, we will have a plan for our standard completion, which will comprise of roughly 34 stages of a plug and perf with a typical design of 24 barrels per foot and 1,000 pounds per foot completion.
E3.
E3 is essentially identical to E2. The only difference is E2 was referencing Three Forks and E3 is referencing the Middle Bakken. But other than that, everything else is the same.
E4?
E4 will show the reservoir properties and economics for the proposed wells. These properties are for the Three Forks and the Middle Bakken. On the reservoir, once again, we're targeting the Bakken and Three Forks. We're looking at GOR of around 700 SCF per barrel initial. Reservoir properties of net pay of 72 feet with an average porosity of 5.5% and 55% water saturation. On an individual well basis for economics, we are expecting an EUR of oil of 676,616 barrels, EUR gas of 373 million cubic feet, which will be estimated recovery factor of about 2.25% on an individual well basis. The economics will run at an average oil price of $65 per barrel and $3.50 per MCF on gas, which will deliver gross sales of $19,654,700, a gross operating cost of just over $7 million, gross income at $13,671,000, and a well gross investment of $6,662,000, with a gross return on investment of 205%.
And exhibit GCP1, is that a gas capture affidavit that the commission typically requires in these sorts of matters?
Yes, it is.
In your opinion, will the requested relief prevent waste, protect railroad rights, and prevent the drilling of unnecessary wells?
Yes.
No further questions off of the exhibits.
Exhibits are admitted. Any questions from the staff?
Scott, is there currently, I guess, alluding to the gas capture affidavit, is there gas gathering in the Twin Buttes area?
I believe there is. It's currently.
And maybe I can answer this question a little bit better. This is James. We do have plans that are being comprised right now to gas capture the area that are underway with third-party gatherers. There previously was not gas takeaway in the area, but we are having plans and construction is underway to make that a reality. My understanding from conversations.
So do any of the wells are any of the wells in Twin Buttes connected?
There are a few wells that are connected to gas, I think on the Twin Buttes exploratory unit, but additional capacity is needed to build to connect these wells in the application lags.
And you anticipate, will that be done when these wells are brought online?
Yes, sir.
Okay, thank you. When is the planned development date for this?
Yes. Right now, the estimated spud on these wells is March of 2027.
Thank you.
Scott, I guess, and possibly James, just a couple extra questions real quick. I guess for James to start with, does Devon have acreage in the east half of 5 and 8?
We do not own mineral interest or at least own interest in east half 5 or 8, no.
Do you know who does?
Cord.
Okay.
I think, yeah, Cord is the overarching, I think it's Oasis Petroleum is the working interest party name.
Okay. And then I guess for James or Scott or whoever knows, do you have any idea what the development plans are for the remainder of 5 and 8, the east half of 5 and 8? Have you had any conversations with them along those lines?
We have had conversations with Cord and also to the effect of, getting letter support, for this application on these lands, to support the development plan that we presented today. I know that they have the east half planned for development, but I can't speak as to when, that timing will occur. We've not talked in detail as to the timing, but my understanding is the development plan on the east half, or I should say on the lease line corridor, is consistent with their plans of development, for that section 5 and 8.
Okay, thank you.
Okay, I will note that barring any objections, I don't assume you won't have, I'm going to admit the letter from Cord that the commission received supporting this application.
In support, do I object to it?
I was just going to say, I assume you won't object.
No, I will not object to it.
Right. So I'll be admitting the letter from Cord dated December 15th that the commission received by Cord supporting the application in this case. Is December 26th long enough to keep the record open? Yes. The record in this case will remain open until December 26th. That concludes the hearing for case number 31478. Moving back to the regular docket. Case number 32438, application of Savannah LLC for an order authorizing the drilling, completing, and producing of the Olympia 3625 3H well with a horizontal lateral located not less than 85 feet from the southern boundary of the 1280-acre spacing unit described as sections 25 and 36, Township 155 North, Range 98 West, Williams County, North Dakota, as an exception to the field rules for the Epping Bucket Pool and such other and further relief. All interested parties, please come forward.
Thank you, Mr. Examiner. Lawrence Bender, P.O. Box 1854, Bismarck, North Dakota, appearing in this matter, case number 32438 on behalf of Savannah LLC. We'll have one witness.
And she's here.
Yes.
Ms. Wallace, please raise your right hand. Do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
I do.
Kelsey, by whom are you employed?
Savannah LLC and Zaveda Energy LLC.
Okay.
Apologies.
That's fine. Well, in what capacity?
I'm a VP of Operations.
Okay. And you're an engineer by education and training, is that correct?
Right. Yes.
And you've had your qualifications accepted as that of an expert?
I have.
And you're going to be offering some testimony here today on some engineering testimony.
Correct.
And you're going to expert testimony on engineering, correct?
Yes.
And then you'll be also offering some factual land testimony. Is that correct?
Correct.
We'll offer further testimony as witness out of an expert.
Motion granted.
Kelsey, let's turn to the packet of
Lawrence, if I could interrupt. So this is listed as being in 15598. Is that the correct township?
Looks like it's in 155. According to the map, it's 155.99. So we could have an advertising problem.
Okay.
So we may have to re-advertise. What we'd prefer to do, if it's all right, is go forward with the testimony and then probably probably won't get on this month in January, but put it on the docket again and just incorporate the record.
Yeah, that would seem to be appropriate.
Okay. Forgot where we're at. But did I have you turn to Exhibit L1?
Yep.
Or, excuse me, Exhibit 1. Okay. Tell us what Exhibit 1 is from a factual standpoint.
Yep. Exhibit 1 is a regional locator map showing our area of interest in Williams County.
And Exhibit 2.
Exhibit 2 is a land plat showing Township 155, Range 99 West. Sections 25 and 26 are DSU of interest, showing Savannah has a working interest of 68.37%.
And Exhibit 3.
Exhibit 3 is a land plat of the DSU immediately south of the DSU of interest. This is Township 154 North, Range 99 West, Sections 1 and 12. This is operated by Whiting with a 72.72% interest. Savannah has a 0% working interest in this DSU.
And this is the spacing unit that's being crowded by your well, is that correct?
Correct.
Okay, let's go to Exhibit 4.
Exhibit 4 is a general wellbore diagram of this well. It has been drilled and completed. So this is post completion information showing a cemented lateral with a wet shear completed with 50 stages, with a dashed line highlighting what we'll zoom into on the next exhibit.
Okay, let's go to the next exhibit, Exhibit 5.
Exhibit 5 is a zoomed in view of the heel of the wellbore diagram showing stage 50 of the completion with perforations above the 150 foot from the south line setback.
Okay, so this is where the encroachment took place, is that correct?
Correct.
Can you just tell us, first of all, how did this happen? I mean, Savannah's drilled a number of horizontal wells. They understand, I assume, the setback requirements for the heel and the toe of the well. Can you tell us just how this encroachment happened?
Of course. So obviously, we're aware of the 150 foot setback, and there were contributing factors, but ultimately, it was an error and mistake. Some of the contributing factors were short setting the 7-inch casing due to being hung up in the shales. We worked with the NDIC to come up with an approved procedure to cement that, perforate and cement above the stuck point. We then ran our liner and ran logs across the 7-inch to confirm that we had isolation, and across the 4.5-inch to confirm isolation across that setback line. And then in a procedural error in the completions procedures, which were based off of an inaccurate liner final depth that showed ICP shallower than it is. Just a calculation error. Top perf was selected on the wrong side of that setback. So we have about 5 clusters closer to the south section line than the setback.
Okay, and we're going to come back to what you did when you found out that there was an encroachment and what you're going to do in the future to prevent this from happening again. But before we do that, let's go to Exhibit 6 and identify Exhibit 6 and tell us the importance of this exhibit.
Exhibit 6 is just a directional layout of this DSU showing on that right portion, you can see the well that's highlighted in red. That's the well in question, and down below shows our casing point and the top perforation relative to the 150 foot setback.
Okay, well, let's now go back to the question that I alluded to a few moments ago. You conducted this operation, you discovered the error. What did you do next?
We were informed of our error by Todd with NDIC Senior Permit Manager, and as soon as we were made aware of this, we started an investigation into what happened and where we went wrong. Since then, we've implemented a multi-step process to ensure that this doesn't happen again, including like procedural changes where we're pulling depths and confirming depths from 3 different sources, making sure that we're not relying on one vendor or one source for the accurate depth, and comparing that to the directional prior to completions procedures being distributed, as well as getting additional eyes on this, making sure that it's not just one person that sends it from the office to the field and that's the only person that ever confirms it. We're getting additional eyes to confirm that we're applying with that 150 foot setback each time.
Now, to solve the problem, what Savannah is requesting is this well be allowed to remain as is, completed as is, and you be allowed to continue to produce the well. So you're requesting basically administrative relief, right? You treat it as an exception.
Correct.
Has Savannah given any consideration into operational relief, going down hole and conducting some sort of operation to solve the problem that way? And if you have, what are some of the problems with an operational solution?
Yeah, so I see there are 2 main ways that we could rectify it operationally. One being a squeeze of sorts, using either traditional cement or a resin or a swell packer type of material to try and squeeze off those perfs that are on the wrong side of the setback. That seems like a lower risk operation, but a lower chance of success as well, getting a good pressure test across that. Some of the risks that are associated with that are if you have any issues reconnecting to your lateral below that, then you could lose access to the minerals that are producing below that, which is the rest of the well in this situation because it is on the heel side. The other option would be a mechanical isolation, such as an expandable liner across this section. This is a higher risk application from the operations perspective. There are a lot more steps involved and things that could go wrong along that way, but it is a higher chance of success of isolating that portion of the lateral. And again, the risk would be losing access to the rest of the formation below that point, which is the remaining wellbore. This DSU does have Bakken and Three Forks development in it, so you can see the closest middle Bakken well that would be in charge of draining this acreage if we were to lose access to the perforations below this section is over 1,000 feet away. Would take quite a bit of time to account for that drainage.
Okay. And in addition to risk of these operational solutions as you've outlined them, there'd be cost, is that right?
Correct.
And the well would be shut in for a period of time while you conducted these operations.
That's correct.
And that means no revenue from the well while you're conducting the operations.
Correct.
Okay. And in your opinion, given the fact that you're only how many feet closer to the hard line are you than you should be?
Our top perf is 85.34 feet from the south line versus the 150-foot setback.
And do you believe that because that distance is relatively minor, there's going to be any correlative rights problems?
I don't believe so. I think that this well produces in line with other wells within the DSU. It doesn't produce at a higher rate or anything that would indicate that that short distance has a huge impact.
And you're aware that the commission, in granting exception locations, always includes provisions in the order giving it continuing jurisdiction to restrict the production of the well in the event it were to determine that there was a correlative rights problem.
Understood.
Okay. Mr. Examiner, that's all the questions I have. We would offer the 6 exhibits that were identified and discussed by the witness.
Exhibits are admitted. Any questions from the staff?
Kelsey, you alluded that you had problems running the 7-inch, and so it's set at 119 feet from the south line. That's correct?
Correct.
On Exhibit 6, in the box towards the center of the page on the top half, to the right of the different directional points, it's, if I'm reading that correctly, it says the casing point is 157 feet from the south line? Or is this, am I reading that correctly?
I believe that is from the surface location.
Are those coordinates?
Yeah, I'm not sure. I would have to check that. Because we do know we do not have 7-inch past that setbacks. That does not appear accurate.
And then your top perfs at 11,302. Were there other perforations, I assume, that were in violation of the setback?
Yes, it's about 5 clusters with 2 perforations per cluster, so 10 total perforations.
In the CBL, if I understood correctly, so where did you perforate the 7-inch at?
For the cementing process?
Yes.
So the 7-inch was cemented above the shales. I don't have that depth to reference, but we perforated above the shales, cemented, laid it on cement, pressure tested before drilling out. We then, after drilling the lateral, OBM because we had shales exposed, we ran a radial log across that 7-inch before running the liner, got approval prior to running the liner, and then did the radial log on the cemented 4.5-inch also.
So did that log show any cement isolation below your perforation?
Yes. Yep, we had approval. that all cement looks good across the setback. I think we logged past 13,000 feet. We had good cement coverage.
I'm talking about the 7-inch.
Oh, I don't recall. I can check that though.
I believe we would probably have those records.
Yeah, we have the logs on file. Just to clarify, those logs were run during the drilling and construction of the well. The completion, I haven't looked at this set of perfs with respect to those logs either. So,
then, but if I understood you correctly, you said you did log the liner and it showed isolation.
Correct.
If you could supplement the record, I'd like to have you submit where you perforated the 7-inch, and then the depth of all the perforations until you get across the hard line. Is the 7-inch set in the middle bucket? Or was it in the shale?
In the shales.
So you couldn't run it into the middle bucket?
Correct.
Okay. Thank you.
Kelsey, on Exhibit 6, just align me real quick here. The well that we're speaking about is I guess it's the second well from the west line.
Correct. There's the lease line drilled from the same location, and then it's the second well within this space.
Okay, it's red and blue on the diagram on the right. And yeah, I think you indicated on Exhibit 3 that 1 and 12 is a unit operated by Whiting. Is that correct?
Correct.
And have you guys had a discussion? Has Savannah had discussion with Whiting about this?
We did reach out to them for information about the mineral owners, but have not spoken with their operations team beyond the land folks.
What's the status of this well right now?
This well is currently producing.
When did it start producing?
It would have been late May, early June.
I'm actually not sure how we normally handle this, but is it such that operators are expected to work together on these situations? Like Whiting and Savannah in this case?
Yeah, I think from my experience, these things do happen from time to time, and it would be, they have to notify the offset operator and owners, obviously, for the exception location. And in my experience, I think all operators understand these things happen from time to time, and I don't recall ever getting opposition to one of these.
Yeah, in my experience, we go back probably, I hate to admit this, but probably 20, 30 years where someone has objected to a situation like this. And just to respond briefly to Mr. Boer's remark, all those owners who's to the south that we crowded, right? They were all given notice of this, and obviously they're not here, so I wouldn't think there was any objection to our request.
Kelsey, do you know when they were notified?
We were made aware of this November 6th. We received that information from court as far as the leasehold, the mineral owners. So it would have been, do you remember when that was sent?
I'd have to go back and look at the file. There should be something of record. It'd be an affidavit or mailing indicating when a copy of the application was sent to all of the owners in the spacing unit to the south.
I'm looking in the case, it looks like late November they were notified.
It's typically done at the time the application is filed or shortly thereafter that everyone has provided notice. Sometimes we have a deadline for filing the application, but we don't have the owners, take some time to put that together, so that sometimes comes later. But as Mark indicated, it will be in the file the date we mailed it out.
Is it normally done, via mail, not necessarily a phone call? I guess it's for Kelsey. Do you guys call Whiting and indicate that,
We haven't. I know that we reached out to get the contact information for their for that ownership, but I've not had a phone call with them.
Okay, thank you.
One more, I guess, question or request. Does Savannah have any opposition to commission taking administrative notice of the logs and its inspection notes during the time frame when that 7-inch was set and cemented and those approvals to proceed with operations were given?
That sounds good.
Okay.
No objection.
Thank you.
No objection.
And then just to clarify what I think you guys are wanting, you'd prefer not to squeeze these perforations or utilize an expandable liner to shut those off. You'd prefer just to continue to produce.
Correct.
Yep. Okay. Thank you.
Yeah, typical order I guess I hate to say typical, but the orders I've written in these situations, they generally request to produce the entire lateral length, and the order will say that it will give it from TD to a certain depth, which will probably be the uppermost perforation, and the board will grant them that authority as an exception to the spacing requirements.
Lawrence, is December 26th okay?
Yes.
The record will remain open in this case until December 26th. That concludes hearing for case number 32438. Number 32439, application of Formentera Operations LLC for an order for the Fraser Bakken Pool, Divide County, North Dakota, to create and establish an overlapping 2560-acre space unit comprised of sections 6, 7, 18, and 19, Township 161 North, Range 97 West, authorizing the drilling of a total not to exceed 4 wells in said proposed overlapping 2560-acre spacing unit, and such further relief as appropriate. This case has been continued to our January hearings. Concludes hearing for case number 32439. Case number 32056, application of Continental Resources Inc. for an order for the Stony Creek Bakken Pool and or Williston Bakken Pool, Williams County, North Dakota as follows. 1. Create and establish an overlapping 1280-acre spacing unit comprised of sections 27 and 34, Township 155 North, Range 100 West, authorizing the drilling of a total not to exceed 6 wells on said proposed overlapping 1280-acre spacing unit, and 2, terminate an existing 1280-acre spacing unit comprised of sections 22 and 27, Township 155 North, Range 100 West, authorizing the drilling of up to 6 wells on said existing 1280-acre spacing unit, and such further relief as appropriate. This case has been dismissed. It concludes hearing for case number 32056. Case number 32440, application of Continental Resources Inc. for an order authorizing the drilling, completing, and producing of the Charleston 8-22 HSL well with the toe of the horizontal lateral located not less than 135 feet from the north boundary of the 5120-acre space unit described as sections 14, 15, 22, 23, 26, 27, 34, and 35, Township 155 North, Range 98 West, Williams County, North Dakota, as an exception to the field rules for the Brooklyn Bakken Pool and such other and further relief. All interested parties, please come forward.
Lawrence Bender, P.O. Box 1854, Bismarck, appearing this matter on behalf of Continental Resources Inc. And we might be able to save some time, Mr. Examiner, by combining and consolidating this case along with case 32441. Similar situation in both cases, wells in the same area, both requests for exception locations.
Any objection by the staff? All right, I will now call case number 32441 as well. Application of Continental Resources Inc. for an order authorizing the drilling, completing, and producing of the Addison 7-23H well with the toe of the horizontal lateral located not less than 143 feet from the north boundary of the 2560-acre spacing unit, described as sections 14, 23, 26, and 35, Township 155 North, Range 98 West, Williams County, North Dakota, as an exception to the field rules for the Brooklyn Bakken Pool and such other and further relief. Will you swear on the witness?
Yes.
Okay. Mr. Newell,
Yes.
do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
I do.
I've probably impacted my credibility a bit in the previous hearing. I said these don't happen too often, and now we have 3 in a row. So, Bryce, are you there?
I am.
By whom are you employed?
Continental Resources.
In what capacity?
As a landman.
And in that capacity, have you testified before the commission previously?
I have.
Have you had your qualifications accepted as that of an expert?
Yes.
Or for further testimony, this witness that of an expert.
Motion granted.
Bryce, let's go to the packet of exhibits for case 32440. Let's turn to L1. Tell us what L1 is.
L1 is a general locator map showing the 8-section DSU in which this exception location is being requested.
Okay, and L2.
Exhibit L2 is a plat showing the 5120 spacing unit comprised of 155 North, Range 98 West, sections 14, 15, 22, 23, 26, 27, 34, and 35 in Williams County, North Dakota, where Continental Resources owns 91.8% working interest.
And Exhibit L3.
Exhibit L3 is a land plat showing the 1280 acre spacing unit in 155 North, 98 West, sections 2 and 11, where Continental Resources owns 80.41% of the working interest.
And Exhibit L4.
L4 land plats of the 1280 spacing unit comprised of 155 North, 98 West, sections 3 and 10, in which Continental Resources owns 93.29% working interest.
And the purpose of the land exhibits that you just discussed, Bryce, is to demonstrate that we do not have common ownership across the spacing unit boundaries. Is that correct?
That's correct.
So the fact that we have a well that doesn't have didn't meet the proper setbacks requires an exception location. Is that correct?
That's correct.
And the engineering witnesses are going to go into further detail as to how this happened, what Continental Resources did, what had happened, when it happened, what it's going to do in the future, and that sort of thing. Is that correct?
That's correct, yes.
And specifically set forth how close the encroachment is. Is that correct?
Yes.
No further questions.
Any questions from the staff?
I guess quick offset spacing unit is owned and operated by which operator? Where the encroachment occurs?
Continental Resources operates both of the adjacent spacing units.
Okay, that's what you meant, Lawrence, when you said common.
Well, it's we have the same operator, but the ownership is not identical, so there is still an issue because Continental does not own the same, and neither do the other owners. So.
Thank you.
Mr. Fisher.
Yes, sir.
Do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
I do.
Steve, by whom are you employed?
Continental Resources.
What capacity?
Completions engineer.
And in that capacity, have you testified before the commission previously?
Not in this capacity, no.
What I'd like you to do is briefly highlight for the examiner and commission staff your educational background and work experience.
Yeah, graduated from the University of Oklahoma with a degree in mechanical engineering. Been employed at Continental since 2009. In my previous capacity, drilling engineer and drilling manager in the Williston Basin for 13 years, and then came over to the completion engineering side in January of 2024.
And in preparation for today's hearing, have you made a thorough study and review of all the relevant engineering matters concerning the 2 exception location requests that are before the commission today?
Yes, sir, I have.
And have you prepared an exhibit or exhibits, excuse me, that you intend to sponsor?
I'll speak to the exhibits. I did not prepare.
Were they prepared under your control and supervision? Did you have involvement in the preparation of these exhibits? Did you direct somebody to prepare the exhibits?
They're frozen.
Oh.
Yes, sir. Yes, we directed the directional company to prepare the exhibits.
Okay. Offer the further testimony of this witness out of an expert.
Motion granted.
Okay, Steve, let's go to what's been, I think there's an exhibit number on here, searching for it. Well, let's just call it E1. I can't seem to find an exhibit number on it, so let's just call it E1. I want to direct your attention to E1. First of all, tell me what E1 is, and then briefly describe what's contained upon it and why it's important for the hearing here today.
Yeah, Lawrence, I'm gonna. Can we get Sam Simcoe pulled in as well? He's in the room with me. He's the drilling engineer on this particular case or cases.
Okay, you guys are. We can hear you for a period of time, and then you cut out. And I guess what I heard you say, Steve, is you want me to call Sam Simcoe?
Yes, sir.
Address this.
Yes, sir.
Okay. Sam, can you hear me?
Yes, sir.
Can you state your?
I'll swear me.
Okay.
Mr. Simcoe, do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
I do.
Sam, by whom are you employed?
Continental Resources
In what capacity?
as a drilling engineer.
And in that capacity, have you testified before the commission previously?
I have not.
What I'd like you to do, as Steve did, is briefly highlight for the examiner and the commission staff your educational background and work experience.
Yes, sir. I'm a graduate of the University of Oklahoma with a Bachelor's of Science in Petroleum Engineering. I've been employed by Continental Resources for almost 4 years and been a drilling engineer in the Williston Basin for almost 3.5. Prior to that, working with ExxonMobil in North Dakota and offshore Guyana.
And were you involved in preparation or directing the preparation of an exhibit that you intend to sponsor?
Yes, sir.
And are you okay with us labeling that exhibit E1?
Yes, sir.
Offer the further testimony of this witness out of an expert.
Motion granted.
Sam, let's go to E1. Hopefully I got the right witness now. Can you identify exhibit E1 and then briefly discuss what's contained on this exhibit and how it's relevant to the request that Continental is making here today?
Yes, sir. Exhibit E1, which the name of the exhibit as E1 is up in the top left corner under the Continental Resources logo. But this exhibit here is a directional plat with at the top showing the well name, what wellbore it is. In this case would be the lateral, the design showing the as-drilled surveys. We have some casing details showing where the 5-inch production casing was set, well name, elevation, and some points of interest for us on just above the map plat showing our TD, our 5-inch shoe, and our frac sleeve.
And what I'd like you to do, Sam, first of all, is explain to the commission why there is a need for an exception location. Why does this not meet the setback requirements of the spacing order?
Yep, so I'll direct your attention to the plot on the left that will show where the TD of our well is for the Charleston 8-22. That's showing TD at 21,851. The TD of that is 133 feet from the north section line, with a 150-foot hard line being our setback set forth by the commission in the permit.
Okay, now Continental Resources is a very active operator in the state of North Dakota. Presumably Continental Resources knows what the setback requirements are for these sorts of wells and knew what the setback requirement was for this well. How did this happen?
This happened due to incorrectly strapped drill pipe, particularly the 4-inch production drill string. And the way that this came about was we were on the third of 4 laterals on the pad. We tagged the float shoe early on the Richmond 6, which is also on the same pad. Conversations started happening of us tagging early. Had the discussion to talk through it and verified it through that float shoe. We ran the traps of talking to the casing company to make sure that we accurately had the correct amount of out joints on our 7-inch casing to make sure we were accurate in that regards. We were, and then going through there, seeing that our pipe was misstrapped. Going through this to correct it in the sense was we added a ghost collar, which would be 47 feet, which was what we were off when we tagged the float. We were going to steel line measure out of the hole once we either TD'd or tripped for a motor. We tripped for a motor at 20,000 feet on that well, and we did confirm that we were 47 feet off from the EDR strap that the rig uses. At this point, we thought with this being the pipe being strapped on this pad when we first rigged up, the thought came, well, we need to go check those last 2 wells because it wasn't brought up. So we ran a casing collar locator, which then confirmed that the Addison well was 45 foot deeper than anticipated, and the Charleston was 39 feet. And basing off this with our standard for the Williston Basin for Continental is TDing the wells 30 foot short of that hard line and being 47 foot off where we come from the 17 feet past the hard line. The Addison you'll notice there is 18 feet. It is actually, we TD'd that 179 feet across the hard line, or not across the hard line, prior to the section line. Sorry, apologies, 29 feet prior to the hard line. And just want to make a note too on the case number header. There are some discrepancies in the footages from the this north boundary. We're planning on filing a sundry to get those corrected. They're actually showing the shallower of the section line than we are, so we just wanted to make sure that that was accurate, putting that in there.
Can you also prepare a supplemental exhibit correcting that information on this exhibit for filing with the commission at a later date?
Yes, sir.
Okay. And you talk about drilling past the hard line. Talk a little bit about for us frac stages and how you're going to frac this well, or how you've fracked the well now that you've drilled past the hard line.
I will hand that over to Steve Fisher, who's the completion engineer.
Okay.
Yeah, if granted.
Well, just stop. I have to finish with you and give the commission an opportunity to ask questions, and then you can testify.
Okay.
Any questions from staff?
So on the Charleston 822 HSL exhibit, you have the footages noted on the left-hand side. Did I understand your testimony correctly? Those are wrong?
No, those are correct. It's the header on the case number for the first page with our logo. Those and the numbers on Exhibit E1 are the correct numbers, sir.
So you're talking about the 135 feet?
Yes, sir. That number is inaccurate. The 133 feet from the north section line is accurate on Exhibit E1.
Okay. So you TD'd 133 feet from the north line. You ran in your casing shoe, and it's 162 feet from the north line.
Yes, sir.
And then I assume you have a wet shoe?
That is correct.
And then your first frac sleeve, 186.
Yes, sir.
So it's essentially the same as a perforation?
Yes.
And is this well, I know it's on confidential status, but do you mind sharing what is this in the Middle Bakken or the Three Forks?
It is the Middle Bakken.
And The well has not been completed?
No, sir. The well is currently temporarily abandoned. So once we caught this, we self-reported to our regulatory group so that we could then come before the commission and request the exception location before continuing any operations.
And when do you plan on completing the well?
It'd be April of 2026.
So essentially you're asking for an order that allows the well to be constructed as is and completed with your standard design?
Yes, sir.
Lawrence, in these orders, we like to identify where the lateral begins and ends, and we grant an exception for that entire lateral length. Then, can you share with me where your 7-inch casing is set, measured depth?
I have to pull that up. Believe this one was. Steve, do you have that number handy right there?
Over you. Take a second.
While he's doing that, Lawrence, are we running through the exhibits in the other case, or we consider we?
The only reason I combined it and consolidated so that I wouldn't have to go through their credentials
So I
twice.
think the land is got the same.
But I don't have any objection.
No, I just wanted to. So I wanted to ask my questions on the other, same questions on the other one, basically, and get them both taken care of.
Maybe this is a good time to address it, Mr. Bohr. But as the witness pointed out, the caption says 135 feet, and it's 133 feet. I mean, given the fact that this case, or excuse me, that the well won't be completed until April of 2026, the appropriate thing maybe is to make application again, incorporate the record, but have it advertised properly so that we don't get into a problem.
Well, my thought on that is, it's only 2 feet. The well and the spacing that were notified, anybody that had an interest in it probably should have been here, and I don't think that error is significant enough to require. But if you want to do it, go ahead.
Well, I don't want to do it, but I don't want to wait 30 days and then the application gets denied because we said 135 and the testimony is 133. I think given the fact that we have some time, I think the prudent thing to do is just advertise it properly and incorporate the record. I know it's cost of putting it on the docket again, but it wouldn't be extra time that the commission would have to spend on it, and it would be done right, and we wouldn't have a challenge down the road. So I'm inclined to
I'm fine
do that. Okay.
So have you tracked down the 7-inch?
We have on the Charleston 8, 7-inch casing is set at 11,538 feet. And on the Addison 7 -23H, the 7-inch casing is set at 11,710 feet.
And then on the Addison well, do we have an issue with that advertising?
What's that?
On the Addison well, what did that one say? It was 143. So you'll have to re-advertise both of them.
I think so. What was the footages on that? I didn't. the correct?
The Addison 7, the footages on that, accurate footages are 132 feet from the north section line.
Did you say 132?
Yes, sir.
Yeah.
So again, I assume you have a wet shoe here.
We do. Yes.
Is this in the middle Bakken also?
Yes, sir.
And not completed. I assume
yes.
You're going to complete this in conjunction with the Charleston well.
Yes, sir.
Yeah, I think I'm good. Same issue, I assume, on this well with the pipe strap.
Yes, sir. This would have been the first lateral we drilled on the pad, with the Charleston being the second.
Okay, thank you. Question on the wet shoe. That's considered your first perforation, right? Not necessarily the first sleeve.
Correct.
Okay.
I've got a head cold, so I'm having a little trouble hearing you. I apologize.
I'll ask it.
Yeah, the toe would be the first take point. Yes.
Now I couldn't hear because somebody else was talking.
Thank you. Thank you.
Sorry, Nathan. You're going to have the completion engineer testify yet?
Yes.
Okay.
Yes.
This is a giant cluster. We'll get back on track.
Okay. You need to admonish your geologist for talking over the top of you. So.
All right.
Okay, we're ready to go on the completion side.
Are we proceeding with the next witness?
Yes.
He's been sworn in. Roll.
Okay. Let me see here. Steve, let's talk a little bit about, we're here today asking that the commission grant exception locations for the Charleston well, and of course we'll talk about the Addison well here in a little bit. What are some alternatives operationally to proceeding? Could you plug back? And if there are some alternatives operationally, what I'd like you to do is discuss briefly for the commission some of the risks and hazards that would go along with those operational things that would solve the problem. Operational solutions, I guess, is what I'm trying to say.
Yes, sir. So, in the case of the Charleston 8 and the Addison 7, the answers would be the same for both. So, obviously, if granted location exception, we would complete the well as normal. If not granted the exception location, we would lean towards isolating the toe of the well, specifically directly above the frac sleeve, which is called out on both Exhibit E1 in both cases. We would set a bridge plug just above that frac sleeve, and our first take point or first perforation from then would be just above that, all being on the correct side of the hard line in both cases. The risk associated with that particular operation, our frac sleeve does not always open during toe prep work. Though we do have a wet shoe, we have the ability to pump down the well, to pump tools down to set that bridge plug. If the frac sleeve does not open, we would be limited to the rate with which we could get through the toe of the well. Sometimes that rate is not sufficient to pump a plug down, 10,000 foot of lateral in this case, roughly. And you can, basically get to the point where you hit diminishing returns and can't get the plug where it needs to go to isolate that sleeve on the correct side of the hard line. The alternative to that is to run in with a bridge plug on coil tubing. It would be set in the same place, just above the frac sleeve there, again, on the correct side of the hard line. And, that becomes a way more costly operation at that point. The risk on the wireline pump down is that you get a plug stuck on your way down. And then subsequently you'd have to rig up coil to drill that plug out and then run the plug on coil after that. Those are the biggest risks on the toe prep work on a wellbore of this nature, and in both cases.
And in addition to the risks that you just discussed for us, there's also costs. There's going to be costs involved in performing those operations. Is that correct?
Correct.
And no guarantee that it will be successful, correct?
Correct. Yes, sir.
That's all the questions I have for this witness.
Any questions from staff?
Yes, Steve, I don't know if I might have been writing notes or if I missed it. So on a standard design, the frac sleeve is designed to be open so you can pump down the first plug?
No, actually, Continental Resources, we don't set a plug on the first stage. We actually pump a smaller stage on the toe stage of the well bore. In our current toe configuration, we do have the wet shoe, as mentioned before, and we have the frac sleeve. The frac sleeve does not always open on the toe prep. It generally opens when we put the first stage on the well, but we do not run wire line and plug for the first stage of the well. We pump out of the toe, and then if the wet shoe, or excuse me, if the frac sleeve opens, then through the toe, the wet shoe and the frac sleeve. Does that make sense? So the frac sleeve is, I mean, the frac sleeve is an insurance policy. It's a design we've had for a long time because we choose not to run a plug on that first stage, given the risk that's associated with it. Typically, when we have a full frac spread on location, we're able to achieve the pressure to open that sleeve. But during toe prep, we've only typically a smaller, 1 or 2 pumps on location. Sometimes we can't achieve the pressure to open that sleeve. But we still have the ability to pump through the toe.
So on a standard ideal design, that frac sleeve is open when you pump your first stage?
In an ideal world, yes, that is the case.
Okay, thank you.
Lawrence, are you going to run through the exhibits in the next case as well?
Yeah, sure.
Okay.
I think we can do that relatively quickly. We'll recall Bryce. Bryce, let's go to case number 32441 and very quickly discuss L1.
Yes, L1's the general locator map showing the 4-section DSU for the Addison exception location.
L2?
L2 is showing the 2560 spacing unit comprised of 155 north, 98 west, sections 14, 23, 26, and 35. Continental Resources owns 91.56% of the working interest.
L3?
L3 is the land plat of the 1280 spacing units, offset the Addison unit. Located in 155 north, 98 west, sections 2 and 11 in Williams County. Continental Resources owns 80.41% of the working interest.
No further questions.
Any questions from the staff? You can proceed.
Okay, Steve, let's go to what we have marked as Exhibit E1 in case number 32441. And can you identify E1 and perhaps just point out any differences that exist on E1 in this case versus E1 in case 32440?
Lawrence, I'm going to hand that one over to Sam Simcoe.
Okay.
Yeah, so the primary difference between Exhibit E1 on 32441 versus E1 on 32440 is going to be your bird's eye view is going to be very similar, showing both wells on that. Primary difference is going to be that left-hand side again, showing instead of the Charleston well and where it crosses that 150 hard line and casing and casing shoe and frac sleeve depths, it's going to now show the Addison with its referred depths in the box above the 10 foot per inch scale there at the top left.
Mr. Examiner, I don't have any other questions for this witness, and I believe Steve covered a lot of the information when he talked about the previous case, what's at issue here. So certainly he's available to answer any questions, but I don't have any direct examination.
Okay. Are you going to call the other witness as well?
No, offer the exhibits in both cases.
The exhibits are admitted. Any questions from the staff?
Where is the toe, the shoe of the well? How far over the hard line is the shoe of the well in each of the wells? The first take.
The casing shoe of each well is actually not over the hard line. We only have open hole across the hard line, sir.
Okay.
So the casing shoe for the Addison is 8 foot short of the hard line, and the casing shoe for the Charleston is 12 foot short of the hard line.
It just has taken a new 12 foot short of the hard line.
Yes, sir. On the Charleston 8-22 HSL.
Where is the end of the open hole?
The end of the open hole for the Addison 7 is 18 feet past the hard line or 132 feet from the north section line. And the Charleston 8, the open hole is 17 feet past the north hard line or 133 feet from the north section line.
Thank you.
I'm not sure it was addressed or not, but I think I'm going to ask Steve on this one. When the wells are completed, the stimulation that you pump out the shoe, I guess, is that the same volume of sand and water as what you'd pump out a typical stage on the way back through the rest of the lateral, or is it modified?
It's modified heavily. Our initial our toe stage on every well, so in this case the Charleston 8 and the Addison 7, is about 1/4 to 1/5 the size of a normal stage we would pump on stages 2 through 30 or 50 or however many stages we have in the well. So the toe stage is a much smaller pump schedule, much smaller volume, and much smaller sand volume to, like I said, either 1/4 or 1/5 of a normal stage.
Okay. And with that kind of smaller stage, I guess the effectiveness of that portion of the stimulation is similarly reduced.
Yes.
And so you wouldn't anticipate that the wells that the open hole portion of the lateral that exceeds the hard line would change or significantly impact the ultimate production from the well.
Correct. It would not impact production of the well.
Okay. Thank you.
Lawrence, does December 26th work again to supplement the
Yes.
record in these cases will remain open until December 26th.
They're going to be continued, so.
But we still want to get this stuff into the record.
We're going to incorporate the record into the continued cases, all right?
Yeah.
Okay. So just try and get
Well,
it by.
We'll get them in by the 26th,
Okay.
and it will be on a later docket. So
Okay.
we'll see if we can get them in today for the next docket. So, no, I'm just joking, sir.
That concludes our hearing for case numbers 32440 and 32441. Case number 32442. In the matter of hearing called on a motion of the commission to consider the confiscation of all production-related equipment and sale of oil at the JW Law 2 well, southwest southeast quarter, section 9, Township 148 North, Range 102 West, Boxcar Butte Field, Mackenzie County, North Dakota, operated by Rocky Top Energy LLC, or any working interest owner pursuant to NDCC 380804 and 380804.9. Ownership parties to come forward. I will note for the record that no parties appeared in this case. Any comment from the staff?
I request that the well file be made part of the record and to take administrative notice of the inspection notes for the well.
Both requests are granted. I will also note that the Commission received an email dated December 17th relating to this case that will be incorporated into the record. That concludes the hearing for case number 32442. Case number 32443, in the matter of a hearing called on a motion of the Commission to consider the confiscation of all production-related equipment and sale of oil at the MOI Squaw Gap 22-9H well, southeast northwest quarter, section 9, Township 146 North, Range 104 West, Homesteaders Gap Field, Mackenzie County, North Dakota, operated by Rocky Top Energy LLC, or any working interest owner pursuant to NDCC 380804 and 380804.9. All interested parties, please come forward. I'll note for the record that no parties have appeared in this case. Any comments from the staff?
I request that the well file be made part of the record and to take administrative notice of the inspection notes for the well.
Both requests are granted. Concludes the hearing for case number 32443. Case number 32444. In the matter of a hearing called on a motion of the Commission to consider the confiscation of all production-related equipment and sale of oil at the Cinnamon Creek 12-15H well, southwest northwest quarter, section 15, Township 145 North, Range 102 West, Cinnamon Creek Field, Mackenzie County, North Dakota, operated by Rocky Top Energy LLC, or any working interest owner pursuant to NDCC 380804 and 380804.9. All interested parties, please come forward. I'll note for the record that no parties have appeared in this case. Any comments from staff?
I request that the well file be made part of the record and to take administrative notice of the inspection notes for the well.
Both requests are granted. That concludes the hearing for case number 32444. Case number 32445. In the matter of a hearing called on a motion of the Commission to consider the confiscation of all production-related equipment and saleable oil at the Federal 12-15 well, southwest northwest quarter, section 15, Township 148 North, Range 102 West, Boxcar Butte Field, Mackenzie County, North Dakota, operated by Rocky Top Energy LLC, or any working interest owner pursuant to NDCC 380804 and 380804.9. All interested parties, please come forward. I will note for the record that no parties have appeared in this case. Any comments from the staff?
Request that the well file be made part of the record and to take administrative notice of the inspection notes for this well.
Both requests are granted. That concludes the hearing for case number 32445. Case number 32446, in the matter of a hearing called on a motion of the Commission to consider the confiscation of all production-related equipment and sale of oil at the Davis Federal 1-31H well, southwest quarter, section 32, Township 151 North, Range 102 West, Glass Bluff Field, Mackenzie County, North Dakota, operated by Rocky Top Energy LLC, or any working interest owner pursuant to NDCC 380804 and 380804.9. All interested parties, please come forward. I will note for the record that no parties have appeared in this case. Any comments from the staff?
I'd request that the well file be made part of the record and that we take administrative notice of the inspection notes for this well.
Both requests are granted. That concludes the hearing for case number 32446. Case number 32447, in the matter of hearing called on a motion of the Commission to consider the confiscation of all production-related equipment and sale of oil at the Cameron Fry 2-36-25H well, southwest quarter, section 36, Township 146 North, Range 103 West, Pierre Creek Field, Mackenzie County, North Dakota, operated by Rocky Top Energy LLC, or any working interest owner pursuant to NDCC 380804, 380804.9. All interested parties, please come forward. I will note for the record that no parties have appeared in this case. Any comments from the staff?
Request to make the well file part of the record and to take administrative notice of the inspection notes for this well.
Both requests are granted. That concludes the hearing for case number 32447. Case number 32049, in the matter of a hearing called on a motion of the Commission to consider the application of of Continental Resources, Inc., for an order authorizing the conversion of the Durant 4-12H well located in a spacing unit comprised of sections 1 and 12, Township 155 North, Range 99 West, Williams County, North Dakota, for the temporary injection of gas in the East Fork Bakken Field pursuant to NDAC Chapter 43-02-05, and such other relief as is appropriate. This case has been continued to our January hearings. Concludes our hearing for case number 32049. Case number 32050, the matter of a hearing called on a motion of the Commission to consider the application of Continental Resources, Inc. for an order authorizing conversion of the Durant 5-12H well located in a space unit comprised of sections 1 and 12, Township 155 North, Range 99 West, Williams County, North Dakota, for the temporary injection of gas in the East Fork Bakken Pool pursuant to NDAC Chapter 43-02-05, and such other relief as is appropriate. This case has been continued to our January hearings. Concludes our hearing for case number 32050. Case number 32051, in the matter of a hearing called on a motion of the Commission to consider the application of Continental Resources, Inc. for an order authorizing the conversion of the Durant 6-12H1 well located in a space unit comprised of sections 1 and 12, Township 155 North, Range 99 West, Williams County, North Dakota, for the temporary injection of gas in the East Fork Bakken Pool pursuant to NDAC Chapter 43-02-05, such other relief as is appropriate. This case has been continued to our January hearings. Concludes hearing for case number 32051. Case number 32052. The matter of a hearing called on a motion of the Commission to consider the application of Continental Resources, Inc. for an order authorizing the conversion of the Durant 7-12H well located in a space unit comprised of sections 1 and 12, Township 155 North, Range 99 West, Williams County, North Dakota, for the temporary injection of gas in the East Fork Bakken Pool pursuant to NDAC Chapter 43-02-05, and such other relief as is appropriate. This case has been continued to our January hearings. That concludes our hearing for case number 32052. Moving to the supplement. Case number 32330, application of RIM Operating, Inc. for an order creating and establishing a 320-acre drilling unit described as the north half of Section 10, Township 153 North, Range 101 West, McKenzie County, North Dakota, authorizing the re-entry of an existing well and completion of the same into the Red River Formation and such other relief. Case has been continued to our January hearings. That concludes our hearing for case number 32330. Case number 32335, application of Continental Resources, Inc. for an order for the Juneau Bakken Pool, Divide County, North Dakota, as follows. 1. Create and establish 3 overlapping 1920-acre spacing units comprised of sections 3, 10, and 15, sections 7, 8, and 9, and sections 22, 27, and 34, all in Township 162 North, Range 96 West, authorizing the drilling of a total not to exceed 5 wells on each proposed overlapping 1920-acre spacing unit. And 2, create and establish 3 overlapping 25, 60-acre spacing units comprised of sections 16, 21, 28, and 33, sections 17, 20, 29, and 32, and sections 18, 19, 30, and 31, all in Township 162 North, Range 96 West, authorizing the drilling of a total not to exceed 5 wells in each proposed overlapping 25, 60-acre spacing unit, and such further relief as appropriate. This case has been continued to our January hearings. Hearing for case number 32335. Case number 32336. Application of Continental Resources, Inc. for an order amending the field rules for the Bockel-Noonan Bakken Pool, Divide County, North Dakota, to create and establish an overlapping 1920-acre spacing unit comprised of sections 23, 26, and 35, Township 162 North, Range 96 West, authorizing the drilling of a total not to exceed 5 horizontal wells in said proposed overlapping 1920-acre spacing unit, and such further relief. This case has been continued to our January hearings. That concludes hearing for case number 32336. Case number 32337. Application of Continental Resources, Inc. for an order amending the field rules for the Upland Bakken Pool, Divide County, North Dakota, to create and establish 6 overlapping 1920-acre spacing units comprised of sections 3, 10, and 15, sections 4, 9, and 16, sections 5, 8, and 17, sections 20, 29, and 32, sections 21, 28, and 33, and sections 22, 27, and 34, Township 161 North, Range 96 West, authorizing the drilling of a total not to exceed 5 horizontal wells on each proposed overlapping 1920-acre spacing unit, and such further relief. This case has been continued to our January hearings. That concludes hearing for case number 32337. Case number 32053. Application of Continental Resources, Inc. for an order amending the field rules for the Fraser Bakken Pool, divide County, North Dakota, so as to create and establish 3 overlapping 5120 acre spacing units comprised of sections 13, 14, 23, 24, 25, 26, 35, and 36, sections 14, 15, 22, 23, 26, 27, 34, and 35, and sections 15, 16, 21, 22, 27, 28, 33, and 34. Township 161 North, Range 77 West, authorizing the drilling of a horizontal well on or near the section line between existing spacing units on each proposed overlapping 5120 acre spacing unit and or such further relief. This case has been continued to our January hearings. That concludes the hearing for case number 32053. Case number 32170, application of Continental Resources Inc. for an order for the Fraser Bakken Pool Divide County, North Dakota to create and establish 2 overlapping 2560 acre spacing units comprised of sections 14, 23, 26, and 35, and sections 15, 22, 27, and 34. Township 161 North, Range 97 West, authorizing the drilling of a total not to exceed 3 wells in each proposed overlapping 2560 acre spacing unit, and such further relief as appropriate. This case has been continued to our January hearings. Concludes the hearing for case number 32170. Case number 32338, application of Continental Resources Inc. for an order amending the field rules for the Border Bakken Pool and or Stoneview Bakken Pool, Burke County, North Dakota, to create and establish 2 overlapping 1920 acre spacing units comprised of sections 3, 10, and 15, and sections 22, 27, and 34, Township 161 North, Range 94 West, authorizing the drilling of a total not to exceed 5 horizontal wells in each proposed overlapping 1920 acre spacing unit, and such further relief. This case has been continued to our January hearings. Concludes hearing for case number 32338. Case number 31676, application of Continental Resources Inc. for an order amending the field rules for the Ranch Coulee Bakken Pool, Mackenzie County, North Dakota, so as to create and establish an overlapping 1920 acre spacing unit comprised of sections 13, 24, and 25, Township 146 North, Range 98 West, authorizing the drilling of a total not to exceed 4 wells in said proposed overlapping 1920 acre spacing unit, and such further relief. This case has been continued to our January hearings. That concludes our hearing for case number 31676. Case number 32341. In the matter of a hearing called on a motion of the Commission to consider the temporarily abandoned status of the Storm Federal 24-30H well operated by White Rock Oil and Gas LLC, Southeast Southwest Quarter, Section 30, Township 146 North, Range 99 West, Grassy Butte Field, Mackenzie County, North Dakota, and such other relief as is appropriate. All interested parties, please come forward.
Thank you, Mr. Examiner. Lawrence Bender, P.O. Box 1854, Bismarck, North Dakota, and I'm appearing in this matter, case 32341, on behalf of White Rock Oil and Gas LLC.
Ms. Bonini,
Yes, sir.
do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
I do. Thank you.
Shauna, I'm having trouble hearing. Can you get a little closer to the mic, please?
Sure. I
Not
just didn't know
much.
if I was being too
Yeah,
much
that's
better.
that's a little bit better. Perhaps just a little closer, or if you can turn up the volume.
Make sure I'm
Maybe you
doing
can't turn up
right.
the volume when you're got the microphone. I think we have to do that on our end. You want to give it a try, Shauna?
Yeah, can you hear me better now?
Yes, that's much better. Thank
Okay.
you so much.
Perfect.
Shauna,
No problem.
by whom are you employed?
By White Rock Oil and Gas.
In what capacity?
I'm an operations engineer.
Okay. And in that capacity, have you testified before the commission previously?
I have.
And have you had your qualifications accepted as that of an expert?
Yes, I have.
To offer the further testimony if this witness is that of an expert.
Motion granted.
Shauna, let's, I assume you have a packet of exhibits in front of you for case 32341.
I do. Yes.
Let's turn to that packet. Let's skip the cover page. Let's skip the table of contents. And then let's go right to exhibit L1. Tell us what L1 is.
So L1 is just a locator map showing where the Storm Federal 24-30H is and just highlighting some potential future development that is just northeast of that well.
And when you talk about potential future development, I think that's what you said. That would be that.
Yes.
That would be that area that's in the it's the area that's encompassed by that red line. Is that correct?
That's correct.
And what sections are those, and what is that, a spacing unit, or is that a number of spacing units?
So we have a spacing unit request. I believe that was continued to January, and that's for sections 8, 17, 20, and 29.
Okay. And that proposal is to drill a number of wells in that area. Is that correct?
That's correct.
And it's that future development that's in your area outlined in red is the reason for your not wanting to plug the Storm Federal 24-38 well. Is that correct?
That's correct.
Okay. Let's go on then to the next exhibit. Well, before we go to that, what are the plans for the for that well that the commission is requesting be plugged and abandoned?
So if you go to exhibit E1, is it possible to go to that one?
Okay, sure. Let's.
So that has the wellbore diagram.
Yeah, if you can
So
address my question
yes,
in
so
conjunction with discussing E1, that'd be great.
Sure. Yes, I think that'd be best to describe that, because otherwise, I think that I would be not making a very good point to for this TA extension if you didn't see the wellbore. So as you can see from the wellbore, we have the Dakotas isolated. We have 7 5/8 casing. So this is a well that does have potential for an SWD. And considering our future development that you are hopeful, proposed future development that was in the L1 slide, that is why we're requesting the TA status to be extended.
Okay. And when is I assume the proposal to convert this well to a saltwater disposal, that's contingent upon your application for further development in this area being approved. Is that correct?
That is correct.
And
yes.
you said that
I mean,
was on the, I'm sorry, I interrupted you.
No,
Okay.
it's okay.
And that application was on the docket for yesterday, but it's been continued to January. Is that correct?
That's correct. That's
Okay.
my understanding.
Okay. And if that application is approved for further development in this area, what are White Rock's plans for that development? Is it 3 months down the road, 6 months down the road? Do you have some anticipated development dates?
I do. I just, so it is anticipated to be, there's a lot of things that go into that proposal. It is expected to be in 2026.
Is the likelihood, if the application is granted for this additional development, that it's going to take place in like I would say the next 6 months?
We would proceed with commencing operations within 6 months. Yes.
And is one of the contingency obviously oil price?
At the current commodity prices, we've determined that we can move forward. So I don't see anything changing. Who knows what the next 6 months provides, but the current commodity prices indicate that this project can move forward.
And where I'm going with this, Sean, is these are your plans, but obviously if the market crashed and oil dropped to $30 a barrel, God forbid, that could alter your that could alter your plans for further development.
That is correct. Again, this is next month's hearing, but I did the economics for that area at $60 flat price oil, which is pretty comparable to what it's forecasting at, with an additional deduct for Bakken crude and other deductions against the oil at that price. So it ended up being, in that 50 price range. And it was still economic at that price range, but yes, I would say dipping down in that $40 to $30 per barrel range would be pretty tough.
So it's a fair statement, is it not, Shauna, that it's all price contingent? If you say here today, we plan on doing this in the next 6 months, a crash could have an impact on your prediction of when you'd go in and do the work.
That is correct.
Okay, let's go on then to the next exhibit, Shauna, exhibit E2. As you did with the previous 2 exhibits, just identify that exhibit and then briefly discuss what's contained upon it.
I'm sorry, which exhibit did you talk? Say
E2.
E1?
E2.
Oh, E2.
Yeah.
E2 is a summary of the previous 2 exhibits, which is just saying that that this is actually an excellent candidate for an SWD. We have the Dakota Isolated. It has 7/5/8 casing. So we could also even run a liner in this well or another casing string. We could run a larger injection string, which helps with injection volumes and pressures. We do have infill development planned in this area, and there is another SWD that's in this similar vicinity, but it is an older SWD. And so with, spending the amount of capital in this area that we predict, it would be prudent for any operator to consider another SWD directly in line with where you're currently operating. And it has easy access for our future developments. It's 6 miles from Highway 85. So, we definitely see this as a potential option for SWD.
And what are White Rock's plans in terms of accepting water at this potential saltwater disposal well down the road? Would it be just White Rock operated water or operated wells water, or would it allow the disposal of water that came from wells that were operated by others, or hasn't a decision been made with respect to that?
There's no decision that's been made, but traditionally we don't, we limit our produced water to the wells that White Rock operates. Okay. Unless there is a previous agreement, which in this case there's not. There are some legacy assets where there was a previous agreement to accept other water. On new disposal wells, unless there is some sort of overriding agreement, we would restrict produced water injection to wells that White Rock operates. It's usually the most common operation. Usually when you build, you're constructing an SWD, it is for the interests of your own company.
And if the commission determined that the explanation that White Rock has given here today as to why this well should not be plugged and abandoned at this point in time, and that White Rock should be given an opportunity to potentially converting the well as a saltwater disposal well, if the commission were to put a time frame on that relief of approximately a year, so that in the event White Rock did not go forward with that the matter would be recalled for White Rock to have an opportunity to further explain why the conversion operation hadn't taken place. Is that something that would be acceptable to White Rock?
Absolutely. I'm just asking for a 1-year extension.
Okay. And from what you've just described, unless there's just some dramatic change in oil price, or you're not granted the requests that are going to be heard in January, you're very likely to go forward with your saltwater disposal well long before that 1 year would pass. Is that correct?
Would we move forward with that if the applications were approved in January? Is that what the question was?
Yeah, I'm sorry. It was probably a poor question, but what I'm saying is if you're successful in getting your applications approved for further development in the area, would you be able to make a decision on converting this well within a year?
I believe that's true, yes. I mean, we would at least start the process. It's a lengthy application process to convert a well to an SWD, and we would absolutely be working with the NDIC to move forward with that process.
Mr. Examiner, that's all the questions I have. Offer the exhibits.
Exhibits are admitted. Any questions from the staff?
Sean, on your exhibit L1, case 32295 that you mentioned.
Yes.
We received a notice from White Rock's legal counsel to dismiss that on 12/5/2025.
From my understanding, I might have the case number. There was some other ones in this area that were proposed, and I apologize. I know that our landman had sent me all of the other new case numbers, and I just must have missed that.
So if this case that's proposed here was dismissed, are you going to be reapplying for the spacing unit?
I apologize. Let me get the other. I know that we dropped some and then revised some and reapplied, which are on the January docket that are in the same Grassy Butte area.
Have you had any discussions with the surface owner for a surface use agreement regarding the disposal?
I have not yet, no. If it's just one of those things that the TA extension is not granted, then we wouldn't need to move forward with talking to the surface owner. Usually we work through plans first to make sure it's a viable candidate before we talk to the surface owner. And then your question, I don't have the docket numbers, but our landman said we withdrew the December applications and are applying for other DSUs in January, which includes 17, 20, 29, 32, and they are all in the CapEx plan. So we do have, in this area, we do have other DSUs proposed that we do plan to develop if approved in 2026. I just wanted to clarify that. I apologize for having that wrong piece number.
And we've had this on TA status since April 8th of 2015 with the past.
That was correct.
Sorry.
That was the very first application, yes.
Yes. White Rock has had it since 2017, and we've gone through TA extensions. In the past years, we've had EOR potential and Bakken casing exits listed. As a reason, SWD hasn't been mentioned since 2019. Is there a reason for the change in plans now?
We are now developing, we had never had anything on the concrete with the, that would be still economic to drill and complete at the current commodity prices. It's been a depressed market since then, but now we do have proposed projects. We've been very successful with these longer laterals, and other companies have as well. So we do see this as potential that is more concrete than we've had before.
Thank you.
Lawrence and Sean, I mean, Exhibit L1 and E1 are, E1 is illegible. L1 is suspect. I mean, we get better copies of those exhibits.
Absolutely.
Absolutely. Yes, that's just putting it on a PDF, on a PowerPoint slide. So I will send you the actual PDF images from Excel and from ArcGIS.
We can probably do better with a little larger scale too. We probably don't need as large of area depicting this as well, Shauna. So perhaps.
And I will put the actual DSUs that we have on our I'll put our actual DSUs we've requested for in January. I'll revise it to include that so that it's more clear. I apologize for that.
Yeah, and I can just maybe respond to Stephen's remark. My docket indicates that White Rock's case 32374 was dismissed. White Rock's case 32375 was continued to January, and White Rock's case number 32376 was dismissed. So if that helps. And then also case number 32295 of White Rock was also dismissed. So of the 1, 2, 3, 4 cases that were filed by White Rock, all were dismissed except case 32375. That's what my docket reflects.
Okay, thank you.
You bet.
When would you like those exhibits by? I can get them to you by the end of the day if that's acceptable.
Well, that would be great. I don't think we need it that quickly. Mr. Examiner, you want to explain?
Well, we'll keep the record open until December 26th.
Yep. Did you hear that?
I did. And yes, you will receive better copies of these files.
Yeah, I'm sorry.
So Sean, White Rock, as you mentioned, or Lawrence mentioned, had several applications for drilling Bakken well. When's the last time White Rock has drilled a Bakken well?
We just completed one. Have to look at the date. In the last month or two.
Was
We
that
drilled three. We did a pad. We drilled 3 wells. 3 mile lateral wells in Montana.
so in North Dakota they haven't?
We have not. No, this is our first new drills in North Dakota.
The
Proposed new drills. I apologize. Proposed new drills in North Dakota.
it appears, I don't know what other cases may be coming, but 32375 looks like it's a couple miles away from this location.
Yeah, I don't know, Shauna, do you know
Looks like
what
it's
32375
let's say
is?
it's 3 miles away.
Yep.
Yeah, I'm not exactly. I didn't measure that. I can give you that distance. Either way, like even a couple miles, considering if you look at all the SWDs in that area, there's just the country roads that White Rock uses currently. And so a couple miles being so close to 85, I consider it still an excellent candidate for an SWD.
So would that water would you anticipate be trucked or pipelined?
And at this time, anticipate being trucked.
And I think I heard you right. You haven't had any negotiations for executing a surface use agreement with the surface owner at this time.
I have not, no.
Okay, thank you.
Okay, I believe we have some individuals who would like to make an appearance as well through Teams. Is that correct? Hello?
Hi, I'm Brittany Storm, the current landowner.
Okay, hold on. Before you start talking, I'd like to swear you in. Are you making an appearance in this case?
I would like to, if that's okay.
Okay. Ms. Storm, do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
I do.
Okay, you can proceed.
Okay. My name is Brittany Storm. I'm currently the landowner out there. I've taken over the property probably within the last year and been running ranch operations out there for the past 4 years. During that time, I've grown up on the ranch. It's been my grandfather's and I inherited it. He's still living out there and residing. The road is very narrow and not well taken care of to get down there. And that's one of the things we've been working on. We just tried to go out there actually yesterday after being away for a trip, and you couldn't even walk down it due to the ice. That being said, if this well was to become in operation again, it's not only approximately 400 yards from the current house that we have out there, which I do feel like is extremely close. And that's one of the reasons we're trying to get it shut down, is because there's not very many places to build out there. And I'm not saying that we plan to build on the well site or anything. It's just one of the reasons we would like to have it shut down. And also due to the safety of our family that's going to be using the road, because we are the ones that have to maintain it. It's not narrow enough for 2 vehicles to pass by at this time, especially if we do have semis going up and down that road. And we have a family of 5 kids that one's just about to get their license, and it's just due to a safety concern. One of our biggest reasons for wanting it shut down, especially it hasn't been in use for approximately 10 years now.
Okay. Anything further?
Not that I can think of at this time. Thank you.
Okay. Attorney Ben, do you have any questions?
Maybe one or two. Hello, Ms. Storm. My name is Lawrence Bender. How are you?
Good. How about yourself?
I'm real good. Just a question to you. You mentioned your grandfather. Is your grandfather the owner of the surface where the well is located?
No, it's now me. And I guess that's another concern, is that my grandfather has kind of made it his storage facility since it has been shut down for so long. And that's a big concern on my part. I don't want to be hit with any fines due to his negligence on that is another thing, because like I said, it's pretty ridiculous what he's left on it, and I'm trying to figure out how to get that off at this time.
Okay, and as I understand your concern, it's mostly focused on the fact that the road is very narrow going in and out of the well site. Did I understand that correctly?
Yes, it's extremely narrow. It's a private road that we put into our own house down there, and then it's probably only fits 2 pickups next to each other, but it definitely would not fit a semi and a pickup.
Okay, and have you made complaints to the Industrial Commission about this well and the fact that it should be plugged and abandoned?
We've been trying to contact them for now, probably about the last year, and I would have to have my husband jumped on and say the routes he's went, because he's been the one kind of going that. It's just been a pursuit that we've made within the last year, trying to get it shut down.
Okay.
As far as the road being maintained or anything, no, we haven't pursued that any further right now.
And trying to get it shut down, I want to understand, have you done that by making contact with White Rock Oil and Gas, or has that been done through having contact with the Industrial Commission Oil and Gas Division?
My husband, if you would allow him to jump on after me and comment on that, he would have the answers.
Okay. You're not aware that there have been any letters or telephone calls to the Industrial Commission complaining about the well not being plugged and abandoned, are you?
I know that he's contacted White Rock and made phone calls. He did talk to one gentleman, and then when he attempted to make more calls to get answers, he wasn't responded to. So I do know that he went another route.
Okay. And if the road were, if the issue with the road were resolved, would that solve your problems?
That would take care of a safety concern on my part if it was one made wider, so that we wouldn't have to worry about any of my kids getting pushed off the road, since they're going to be new drivers, and then maintained, because like I said yesterday, we went out there just to go check on my grandpa, and if he needed an ambulance, he couldn't get one down there. They'd end up in the trees.
And you're aware that if this well were converted to a saltwater disposal, the owner of the surface would be compensated for the injection of saltwater. Do you understand that?
I am aware of that.
Okay.
And that I guess I'm not too concerned about that. We kind of just wanted to have our pretty place back.
Okay. Sure.
Not feel well, if that makes sense.
Right now, you aren't receiving any compensation for the well as it sits. Is that correct?
Correct. No, we're not.
Okay. That's all the questions I have. Thank you very much, Brittany. I appreciate you answering my questions.
Thank you.
Any questions from the staff?
Brittany, if you were approached by White Rock for a saltwater disposal surface use agreement and they addressed your concerns with the road, widened it, would it be something that you would consider?
I would have to take into consider my husband's answer on that response. At this time, no, we're looking to just have it all closed off and be done, to be honest, because it wasn't really well maintained previously.
Thank you.
Thank you.
Brittany, just explain to me, the road is common with your house or your grandfather's house. Explain the road, the commonality of the road. I'm looking at a map here, and I think I know what I'm looking at, but I'm trying to understand it. Is the house north and a little bit east of the well?
Correct. Just a little bit northeast of the well. And we would use the same road as the truckers would be using going up and down that. There's only one way in, one way out. And like I said, it's pretty rough right now to even get one vehicle down there.
Is that your primary residence?
Correct. Yes. My husband and I will be moving out there in May. And we're just waiting for our kids to finish school. We didn't want to move them in the middle of school year. And we've been currently, like I said, going out there for the last 4 years, running the ranching operations.
And right now the access to that is on, I guess it says Road 850. Is that right?
I don't have yes, I do believe that's correct. I don't have it pulled up in front of me, but yes.
Off of County Road 50 going to the north through section 31 into section 30, I think. I think
that sounds right.
Okay, thank you.
Thank you.
Okay, it looks like we have Hunter. That's what I'm going to ask right now. Is your husband Hunter Voss?
Affirmative, yes. He's on here too.
Okay. Would he like to appear in this case? He can answer.
Yeah, if I can add just a little bit.
All right, let me swear you in. Mr. Voss, do you solemnly swear or affirm under the penalties of perjury that the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
I do.
Okay.
Mr. Examiner, I didn't catch the last name. Hunter
Voss, I believe. Voss.
Okay. Thank you.
Just on the, you guys had asked my wife Brittany about if we had contacted the, I think it was the industrial gas or something along those lines. Kind of looking into this well. Originally, when we
I'm sorry, Hunter, we're having trouble hearing you. Is there any way you can?
Sorry, can you hear me a little better now?
A little bit, yep.
Okay, sorry, I have a little sickness, so I'm trying my best here. But when we originally talked or were looking into the well and what was going on, what White Rock's plan was with it, I attempted to contact White Rock, and I got in contact with somebody out of their, I think their Texas office somewhere, and he informed me he would look into it, and that was in August of this year. But following that conversation with him, I think I was only able to get in touch with him one other time, and I got the same answer as far as he just said we're going to look into it. So that was when I contacted the North Dakota Oil and Gas to see what we could do about the well.
Okay, anything further?
Nope, I don't have anything further.
Okay, Attorney Bender, do you have any questions?
No questions. Thank you, Mr. Examiner.
Any questions from the staff?
Hunter, did you say that you contacted the Department of Mineral Resources?
Yes.
Okay, and about when did you do that, and who did you talk to?
Talked to, let me just pull up my email real quick here. I think his name was Steven.
Yes, you had spoken with me.
Okay, Stephen Freed.
Yep.
Okay. You've written. Yeah.
Trying to think of when my first email with him was. It was, I think, September sometime. Yep, it would have been September is when I contacted him.
Okay, thank you. Did I guess another question, Hunter? Did White Rock ever get back to you? They had indicated that they would look into it. Did they call you back, or was that the expectation that you had? Is that you would receive a phone call?
Yeah, when we originally talked, he said he would look into it and let me know. And then, yeah, never did hear back from him. I do not remember who it was, or it would have been another Texas office, I believe.
Okay, thank you.
So Hunter, when you contacted White Rock with that, was that just to find out what the plans were for the well, or was there any other issues that you wanted them to address?
I was kind of looking at what I wanted to see what what the contracts were the well, because like we've been looking into trying to build a house somewhere out on that property besides the one that's currently down there that our grandfather's living in. So I was trying to figure out what kind of easements they might have had, or what their contracts were for that well.
Okay, thank you.
As well as what their plan was. Yep.
Okay, thank you.
The record will remain open in this case until December 26th. And that concludes our hearing for case number 32341.
May I just, we're going to be filing some things with the commission, and if Ms. Storm or Mr. Voss wanted to provide the commission with an email address, we'd be happy to copy them on anything we file with the commission. So I offer that to Ms. Storm and Mr. Voss.
Okay. Did you hear that, Mr. Voss and Ms. Storm?
Yes, sir.
Okay.
Yes, I heard.
And
How would you?
please make sure they have my contact information as well. I believe I can get a faster turnaround, get their questions answered a little bit quicker.
I didn't hear what you said. Did you?
If
give her
you would give them my contact information as well, I did not realize they were trying to reach us, so I will reach out to Brittany and Hunter.
Okay, so as soon as I get an email address through the Industrial Commission, I'll provide that to you, Shauna, and then
Yes, please do. Yes, I would appreciate that.
Yeah, I don't want Ms. Storm and Mr. Voss to provide that over the internet, so I think it's
For sure.
they supply it to Steven. So
yeah, that will be coordinated internally. Okay, that concludes our hearing for case number 32341. Case number 32342 on a motion of the commission to consider the proper spacing for the development of the Grassy Butte Tyler Pool, Mackenzie County, North Dakota, redefine the field limits and enact the special field rules as may be necessary. All interested parties, please come forward.
thank you, Mr. Examiner. Lawrence Bender, P.O. Box 1854, Bismarck, North Dakota. Appearing in this matter, case number 32342 on behalf of White Rock Oil and Gas, LLC. The commission should be in receipt of a set of exhibits that should provide all the information the commission needs to render a decision in this case. In the event the commission requires additional information, we'd be happy to supplement that, or the commission wants to put it on for another hearing. We can't call a witness, but we believe what we've submitted should supply the commission with what it needs.
Any comments from staff?
Not at this time. I haven't looked at it.
Take a look at it, right?
Okay, so the exhibits will be admitted to the record?
We'd offer the exhibits.
Okay. Yeah. The exhibits are admitted. That concludes our hearing for case number 32342. Case number 32253, application of Silver Hill Energy Operating LLC for an order amending the field rules for the Stoneview Bakken and North Tioga Bakken pools, Divide County, North Dakota, to modify an overlapping 2560 acre stand-up spacing unit comprised of all of sections 13, 24, 25, and 36, Township 160 North, Range 95 West, and authorizing the drilling, completion, and production of a total not to exceed 3 horizontal wells on such proposed spacing unit and such other relief as appropriate. This case has been continued to our January hearings. That concludes our hearing for case number 32253, and that concludes our hearings for the day.